House will come to order. Message from the Senate.
Message from the Senate, Mr. Speaker. I hereby announce that the Senate exceeds the request of the House to a conference committee on the amendments adopted by the Senate to House File 677, an act relating to financing of state and local government. The Senate has appointed as such committee Senators Skoy, Rest, Dietzig, Coonan, and Senjum. Signed, Joanne M. Zoff, Secretary of the Senate.
Calendar for the day. The first bill on the calendar for the day is Senate File 541. The clerk will report the bill.
Senate File 541, number 5 on the calendar for today, the second engrossment, an act relating to liquor.
The author of the bill, Representative Atkins.
Thank you, Mr. Speaker and members. Good afternoon. This is the annual liquor omnibus bill. This is the 6th or I think now 7th year that I have carried it, both when we've been in the majority and in the minority. The point of this bill is to not, rather than even call it bipartisan, I would say it's nonpartisan. There's a number of provisions from members on both sides of the aisle, mostly designed to serve local communities that have run into need for clarification of some of Minnesota's liquor laws. And I will go through those provisions, and then we have the individual authors of the provisions who would be available, in addition to myself, to answer any questions that members may have. We are working off the Senate language, which is very close to the House language, and that's why we just took and decided to work off the Senate file. Section 1 is a brewer taproom license fix. It's Representative Hillstrom's bill. Section 2 is Representative Fransen's bill. It provides samples from microdistilleries. Sections 3, 4, and 5 allow small brewers to sell growlers and a local fee if it's necessary to be regulated. Section 6 is malt liquor, which is a beer educator license. We've done a wine educator license last year. This is Representative Dabney's bill, as is Section 7, which allows for beer tastings by nonprofits. Section 8 allows the Twin Cities Marathon to have a license to serve beer at the end of the Twin Cities Marathon. They've long had that. It's just that they changed their name, and Representative Lilly caught that need for a little tweak in the license for the Twin Cities Marathon. Section 9, Representative Gunther, is the Winnebago Brewfest or Beer Fest license down along the border. Section 10 is for the St. Paul Saints at the Lower Town Ballpark. This is Representative Johnson's provision. Section 11, there was clarification regarding sake, which I've never actually had before, but apparently our staff got some concern about which section that fits into, so they found a spot in the statute for it. Section 12 is Representative Beard's provision relative to Valley Fair. Just so you know, we're not looking to serve beer to kids. Valley Fair already has a couple of licenses. This just clarifies an additional license. Section 13 is a relaxation of the food service rules for the City of St. Paul. What that means is that under existing law, there's a 60-40 requirement, which means 60% of your revenues have to come from food and 40% from alcohol. With craft brews in particular, there's a few that where the cost of the alcohol, the cost of the beer has gone up a little bit, and it's getting closer to a 50-50 margin in terms of where the revenues come from. So the City of St. Paul asked for that clarification. You'll see shortly there's an amendment relative to the City of Minneapolis, which is facing the same issue. In practical words, what that means is, for example, Representative Paymar, who brought this provision forward on behalf of the City of St. Paul, the Groveland Tap, which has been around for a long, long time, just a great place, would not be able to meet that because they are, I think they're the biggest seller of Summit beer anywhere in Minnesota, which is a little bit more expensive. It's a craft brew. But the point is that they end up being off-kilter from the 60-40 rule and would no longer be able to pass that 60-40 rule. There's a couple of amendments that will be coming, which we'll talk about when those amendments come up, but short of that, I'd be happy to stand for questions that members may have, and I'm sure those with provisions in the bill would be happy to stand for questions as well. Thank you, Madam Speaker, and thank you, members.
There's an amendment at the desk. The clerk will report the amendment.
Atkins moving to amend Senate File 541, the second engrossment as follows. The amendment is coded A1.
The member from Dakota, Representative Atkins.
Thank you, Madam Speaker. And Madam Speaker, I don't think your microphone is quite working yet, but the reason I took a little while to explain what we're doing in St. Paul is because this amendment just does the same thing in Minneapolis. It's the 60-40 exemption. City councils would still have a right to be in, or would be in control of it, but it would provide for that possible exemption for the city of Minneapolis. It's already in the bill for St. Paul.
The member from Hennepin, Representative Anderson.
Thank you, Madam Speaker. Members, I support the Atkins amendment, but I think it highlights the problem that we have here in the state. Last week, as you know, you passed the Omnibus tax bill. And in the Omnibus tax bill, we voted to, or I didn't vote for it, but you voted to raise the beer tax on beer by 600%. When we're raising taxes on beers by 600%, it's going to make it even more challenging for the communities of St. Paul and Minneapolis to have their local restaurant owners abide by the 60-40 rule. So, you know, our actions on the tax bill have consequences. We're going to make it even more onerous for these facilities to meet that 60-40 threshold. And I'm glad that we're trying to fix it here today in the Omnibus liquor bill. Thank you.
Discussion to the amendment. Seeing no further discussion to the Atkins amendment, all those in favor of the amendment, please say aye. Aye. Those opposed, please say no. The motion prevails. The amendment is adopted. There's an amendment at the desk. The clerk will report the amendment.
Simonson moving to amend Senate File 541, the second engrossment as follows. The amendment is coded 061.
The member from St. Louis, Representative Simonson.
Thank you, Madam Speaker and members. This is a simple amendment that simply provides the City of Duluth with the authority to issue an on-sale intoxicating liquor license for Wheeler Field, which is one of our primary softball tournament locations in Duluth. This bill actually did have a hearing in the House and was included in the final House bill, but because we're working off the Senate version, this amendment is necessary. So I would ask for your support.
The member from Isanti, Representative Doubt.
Thank you, Madam Speaker. I'd move for a call of the House.
Representative Doubt moves for a call of the House. Seeing 10 hands, there will be a call of the House. The clerk will take the roll on the call of the House. Representative Murphy.
Thank you, Madam Speaker. I move that further proceedings under the roll call be dispensed with and that the Sergeant of Arms be instructed to bring in the absent members.
Representative Murphy moves that further proceedings under the roll call be dispensed with and that the Sergeant at Arms be instructed to bring in the absent members. All those in favor, please say aye. Aye. Those opposed, please say no. No. The motion prevails. The clerk will close the roll and the Sergeant at Arms will bring in the absent members. Discussion to the Simonson amendment. The member from Carver, Representative Hoppe.
Thank you, Madam Speaker. Members, this Representative Simonson amendment is the kind of thing that happens all the time. It seems like every year we have one of these amendments that comes after we hear the bill in committee. I would encourage members to give this a green vote. Thank you.
Seeing no further discussion to the Simonson motion, all those in favor of the Simonson amendment, please say aye. Aye. Those opposed, please say no. The motion prevails. The amendment is adopted. There's an amendment at the desk. The clerk will report the amendment.
Schoen moving to amend Senate File 541, the second engrossment as follows. The amendment is coded A3.
The member from Washington, Representative Schoen.
Thank you, Madam Speaker and members. This is the amendment that extends beer sales to Mariucci and Williams Arena at the U of M. The University of Minnesota did about $1 million worth of beer sales at TCF Bank Stadium last year. and according to my figures, that's approximately about $80,000 in revenue to the state of Minnesota in form of taxes. And let's face it, folks make that beer, folks deliver that beer, and folks pour that beer, and that's a good jobs bill. But the bottom line is that this shouldn't just be about premium seating members. This should be about the common folk of Minnesota like you and me. And when I go to the U of M, I think we can extend those to the areas where they already sell beer and premium seating. So you won't see venues that don't sell alcohol listed, because we're not going to force them to do something they don't want to do. So I'd urge a green vote.
The member from Dakota, Representative Atkins.
Thank you, Madam Speaker, and thank you, Representative Schoen, for offering the amendment. As folks who've been here for a little while know, I supported the TCF version of this a couple of years ago. But what people may not remember is that I also supported giving the university an opportunity to think it through on their own before the legislature imposed our will upon them. And while I support, and I think most Minnesotans would probably say the same thing, Representative Schoen, and that's why I like this idea of extending so that a regular Joe Sixpack or Jill Sixpack at a hockey game or a basketball game can also get a beer. It's something that the university testified when we heard this bill in committee. The university's officials represented that this is something that they're thinking about. They'd like an opportunity to work through it on their own before the legislature decides to impose it upon them. And I hope that they will, and I think that they will. It certainly helped a lot at TCF. I think the reduction in alcohol-related incidents when this went into place at TCF was something like a 43% reduction. And my two sons who attend the university, they said, it's kind of common sense. A lot of folks stopped binge drinking before they went into a game, and a lot of folks stopped sneaking beer and harder liquor into the game in order to try to have liquor while they watch the Gophers football team. So I think it makes a lot of sense. I'd just like to give the university an opportunity to think about it on their own. And I guess my request, Representative Schoen, I respect what you decide to do, but perhaps withdrawing it this year and letting the U work on it, and then we'll see what happens next session.
Representative Schoen.
Well, Madam Speaker and Representative Atkins, I do agree that they probably need a little bit more time over at the U, considering they came into committee and said that they only made $16,000 on $1 million in beer sales, and then short time after, the press called me and advised me that they had read the spreadsheet wrong and actually lost $16,000 on $1 million in beer sales. So, quite frankly, it seems like they probably do have a few things to work through, and with that, Madam Speaker, I'll withdraw the amendment.
Representative Schoen withdraws his amendment. There's an amendment at the desk. The clerk will report the amendment.
Sundin moves to amend Senate File 541, the second engrossment as follows. The amendment is coded A2.
The member from Carleton, Representative Sundin.
Thank you, Madam Chair. This is a very simple amendment that allows wine sales in a mom-and-pop pizza shop in Esko, Minnesota, and I appreciate your support.
Representative Atkins.
Thank you, and Madam Speaker, members, this fell into the same category as Representative Simonson's earlier bill with respect to Wheeler Field and Duluth. Made it through the House, was in the House version. It's just that we're working off of the Senate file. So I think everybody in committee supported it. I'm looking at Representative Hoppe, who's nodding, and I'd ask for your support for the amendment as well.
Seeing no further discussion to the amendment, all those in favor, please say aye. Aye. Those opposed, please say no. The motion prevails. The amendment is adopted. There's an amendment at the desk. The clerk will report the amendment.
Liebling and others moving to amend Senate File 541, the second engrossment as follows. The amendment is coded 063.
The member from Olmsted, Representative Liebling.
Thank you, Madam Speaker and members. Members, usually when we hear the Omnibus liquor bill, the really exciting part is the part we're getting to right now, and that is whether we should allow Sunday liquor sales in Minnesota. Only 12 states, as far as I'm aware, are with Minnesota in not allow, or I should say 12 total don't allow liquor sales on Sunday. And of course, most of you know that Minnesota allows you to buy liquor in a bar on Sunday, but you can't buy liquor in a store on Sunday. My amendment would change that. Most of us in this body, I think, would say that we support the free market. We believe that competition, in many instances, in most instances, is good for our economy. We believe that competition reduces prices, that it makes innovation, and that generally it's good for consumers. We don't allow industry collusion in this country. That's called antitrust. And why don't we? We don't because it's bad for consumers. We believe that competition is a good thing. And that's what we do for most retail and most services. We allow and we encourage competition. We don't allow businesses to set minimum prices, get together, for example, and set a minimum price to charge for a haircut. That would be anti-competitive. We don't tell restaurants how many servers they have to have per table. That would be anti-competitive. We don't let them get together and decide how many servers they should have per table. That would be collusion. We don't tell small businesses what days they can open. And if they came to us and said they want us to do it for them, we'd say no. I'm sure that every small retailer, well, I'm not sure, but it's quite, well, one could imagine that every small retailer and service business in the state would like to have a no competition day. But if they came and asked us for that, we'd say no, because it's bad for consumers. But there is one industry in which we do that. We let liquor store owners be non-competitive. We tell them, sure, we'll give you a day when you don't have to open, when you don't have to worry about the competition. We say no liquor can be sold in a store on Sunday, and we let them set those terms. So I have no doubt that many of you have heard from your small store owners, and I have no doubt that there are many businesses who don't want to open on Sunday. And to them I say that if my amendment becomes law, you don't have to open on Sunday. It simply becomes your choice. And most importantly, consumers will have the opportunity to buy a bottle of wine or a six-pack of beer and bring it to their home and consume it, even if it's Sunday, because maybe some store owner will decide that they want to compete on that day, and we will simply be allowing them to do it. We only allow 2 industries in this state to preserve a day to have no competition. And unfortunately, only one of them is germane to the liquor bill. Otherwise, I'd be trying to do this for both of them. And I think you all know I'm talking about auto dealers. They're lucky they're not germane to the liquor bill, I guess. Because frankly, I'd like to buy a car, and I want to shop on Sunday, and I can't, because this legislature has forbid them from being open on Sunday. But for liquor stores, it's time to change this, members. We don't tell the bars to close on Sunday. If this is about access to liquor, perhaps we should be telling the bars they can't be open on Sunday. But it's not. It's only about people who want to buy a bottle of wine because they have friends coming over for dinner and they forgot to get a bottle of wine. Or, for whatever reason, many responsible drinkers in the state, responsible consumers, simply want the opportunity to shop on Sunday, which is a day that many people want to go out and shop, a day that many of them are not working. And we should not allow an industry to say we don't want to compete on one day of the year, on one day of the week. Keep this day for us so we don't have to compete. And that is what we are doing if we vote down this amendment. So I know that some other members probably want to speak to this. I just want to reiterate that if we put this amendment on the bill and this amendment becomes law, no liquor store will have to open on Sunday. We will not be telling them to open on Sunday. We will simply be removing the impediment to their doing so. We will be giving our small businesses a choice. And they will make that choice the same way they make the other choices that they make. They'll decide whether their customers are demanding it and what they need to do to compete and be successful in the marketplace. And I think that is what we want them to be doing. We don't want to be engaging in a kind of protection from competition, which is what it represents, this policy that we have now. So I ask for your support of the amendment.
There's an amendment to the amendment. The clerk will report the amendment to the amendment.
Khan moving to amend the Liebling amendment as follows. The amendment is coded A4.
The member from Hennepin, Representative Khan.
Madam Speaker and members, I've been involved in this issue for a long time, and I was very glad to see Tina taking it on, because I always think a change in face is helpful as we do this. Although it did occasion, last time when I had it, I did get the nicest letter I'd gotten from the session from Representative Drazkowski's mother, who said it was so nice to see us working so well together. And that gives you an idea. So I guess Representative Liebling may get it this time. But anyway, I've listened to a lot of the testimony on this, and some of the testimony that we've heard from the liquor store owners is that they will, if they're open 7 days, they will spread 6 days sale over 7 days, and it's just not worth it to them. Then when you ask them, of course, well, you could make that competitive decision, they'll say, well, we can't make that decision because if everyone else is open on Sunday, we'll have to. So I think my amendment to Representative Liebling's amendment answers that question by saying we'll keep the idea that liquor stores will be closed 1 day a week, but we'll allow them to make that decision, and then that will give a whole other arena of choice for that decision to be made. So I would hope that people will support this amendment.
Representative Atkins.
Thank you, Madam Speaker, and thank you, Representative Khan, for bringing the amendment. This is the challenge with proposing amendments on the House floor that haven't had a hearing. My question for consumers that might be interested, what the amendment says, by the way, is that a liquor store must be closed 1 day every week. So as a consumer, you pull up on a Tuesday, and this may be that the liquor store is now closed on Tuesday or Wednesday. The one thing we have certainty right now is that liquor stores are closed on Sundays. But under this amendment to the amendment, it would say that it's just sort of hit or miss, sort of hopscotch type approach. Might be closed on Monday, might be closed on Thursday, you just don't know. So when you pull up to your local liquor store, you're not going to know. From a business owner's standpoint, and maybe just by a show of hands, how many of you talked to your local liquor store owner about this? So some of you have. About the Khan amendment of which would cause them to be closed 1 day per week, but we don't know which way or which day that may turn out to be, or what that may turn out to be. The reason we have hearings, particularly on things that are going to impact people's livelihoods, is so that they have an opportunity to say what that impact may be. And I talked to Representative Khan earlier. I do think this is worth a hearing. It's unfortunate that it came as an amendment on the House floor, that most of us haven't had an opportunity to visit with our local business owners. We haven't had a chance to talk to consumers about it, let alone if you have munis in your district and you haven't spoken with your local mayor or city council. I suspect that they may have an opinion as well. For that reason, I oppose the amendment. I've talked to Representative Khan, though, about possibly giving this a hearing next session. So I find it kind of an intriguing idea and a unique way to address an issue that has arisen in the past. I just don't quite know what the answer is in terms of what that impact may be.
Representative Khan.
Madam Speaker and Representative Atkins, I should look very favorably on that offer, although I have about 4 or 5 bills in your committee right now, of which I asked for a hearing on every one, and none of them ever got a hearing, except for one after the deadline, an informational only hearing. So you know, as I said, I have ultimate trust in you, but trust is always tempered a little bit by experience. And what happened was that I went to the hearing that you did have, and I listened to the number of people who said again and again that they don't want to spread 7 days profit over 6 days. This gives them the opportunity to do this. And I would tell you, Representative Atkins, the difficulty if you go to your local liquor store and it's closed, there's probably another one a couple of blocks away, maybe a mile away, that will be open on Tuesday. You know, the same thing happens when you go, restaurants often close 1 or 2 days a week. There's another problem about restaurants that aren't whenever, which is the time we usually like to go out to eat late at night, and they're not open. You often just have to get there and find out that that's the effect. But I think the liquor stores will have the ample opportunity. I don't know what your deadlines are or what happens or so forth. They'll have ample opportunity to inform their customers what day they will be closed and let the customers make their choice. But it's much more harmful to the customer to have every single store of this kind closed on Sunday than just to have their one favorite store closed on Tuesday.
The member from Dakota, Representative Garofalo.
Thank you, Madam Speaker. I would request a roll call on the amendment to the amendment.
Representative Garofalo requests a roll call on the amendment to the amendment. Are there 15 hands? Seeing 15 hands, there will be a roll call on the amendment to the amendment. Discussion. The member from Wabasha, Representative Drazkowski.
Thank you, Madam Speaker. Well, Madam Speaker and members, I'm not really too fond of the amendment to the amendment, but I think it makes a very good point. And Representative Atkins, the Minnesota Licensed Beverage Association, which has their hands around this issue in this body and has controlled it in the past, and I expect probably will today, seems to always claim that, well, if you take away the regulations that government provides these businesses, the limitations that our statutes provide on these businesses to operate, we will be forced to be open 7 days a week. That's their argument. So, members, if you subscribe to that notion, if you truly subscribe to that, which I believe is a straw man argument, they don't have any problems in Wisconsin across the border from me. The business owners discern for themselves which days to be open, which days work. They may be open 6 days, 5 days, 7 days, and they may choose which days those are. But if you truly subscribe to the notion, that argument, if you truly subscribe to it, that they'll be forced to be open if Sunday sales happens, then members, this is the amendment to the amendment for you. If you truly believe that's the case, this amendment to the amendment would completely remove that worry among those people who make that argument. So if you believe that, I'd encourage you to support the amendment to the amendment. If not, and you believe it's a straw man, like I do, I'd encourage you to oppose it. Thank you, Madam Speaker.
Discussion. Representative Liebling.
Thank you, Madam Speaker. And Representative Drazkowski, your mother would be proud. We're working together today, as Representative Kahn said before, and I appreciate your comments on the amendment to the amendment. Members, I agree with Representative Drazkowski on this. I don't really support the amendment because I really think that we should allow these businesses to decide for themselves. And I think it is a straw man argument, Representative Drazkowski, and they've used it for far too long. So what I would say, members, is if putting this on my amendment would help you vote for it, then by all means vote for the amendment to the amendment. But whether this goes on or not, I hope you'll support the underlying amendment to give these businesses the same freedom and the same choice that other businesses have in the state, and that is to figure out when they think they should be open and closed.
Discussion. Seeing no further discussion on the amendment to the amendment, the clerk will take the roll. Representative Murphy.
Thank you, Madam Speaker. I move those not voting be excused from voting.
Representative Murphy moves that those not voting be excused from voting. All those in favor, please say aye. Aye. Those opposed, please say no. No. The motion prevails. The clerk will close the roll. There being 5 ayes and 122 nays, the motion does not prevail. The amendment to the amendment is not adopted. To the amendment. Discussion. Representative Garofalo.
Thank you, Madam Speaker. I would request a roll call on the Liebling amendment.
Representative Garofalo requests a roll call. Seeing 15 hands, there will be a roll call. Discussion to the Liebling amendment. Representative Doubt.
Thank you, Madam Speaker. I might as well speak on this. There's 2 groups of people in Minnesota that don't want this. The people who actually own the liquor stores and anybody who works in the car business. So, and they see this as a slippery slope. And I know Representative Liebling mentioned that earlier when she spoke. But the fact is simple. Liquor stores simply don't want this. Maybe a couple of the larger ones do, but your mom and pop liquor stores all over Minnesota do not want this. And they are not the ones asking for this amendment. So I very strongly encourage people to support their mom and pop liquor stores, and they see this as increasing their overhead by 15% without increasing sales. And it's very simple. They do not want this. If we do pass this, they feel that they will be forced to be open on Sundays to compete with the big box liquor stores that are encroaching on territory they've had for years. So this would be a vote in support of the Walmart big box type stores. I don't know if Walmart has liquor stores, but whoever has them, the big box guys, and a vote against your small mom and pop liquor stores. So I would strongly encourage a no vote. And as somebody who has worked in the car business in the past, they don't want this either.
Representative Drazkowski.
Thank you, Madam Speaker. I'd have to take exception to the minority leader's characterization. All due respect to Representative Doubt, but I've got a liquor store owner in my district. He lives in Wanamango. He spoke at the informational hearing that the Representative Atkins held. And Representative Atkins, I wish you'd have a real hearing. I mean, I've been hearing the thing for years about, well, maybe we'll hear it next year. But I do give you credit. You had an informational hearing, and thank you. But he spoke at that hearing, and he's not even on the border. He's a good hour and a half or hour and 15 minutes at least from the Wisconsin border. But he realizes the weaknesses of the argument. He realizes that a business owner, he's got the ability to make those decisions going forward. And it's small businesses. It's all businesses, especially when you get along the borders. I've got 3 bridges to Wisconsin within either in or very near my district at Winona, Wabasha, and Red Wing. And let me tell you, you go across the border on Sundays and those liquor stores across the border are buzzing. Some of them do very significant 30, 40, 50% of their business on Sundays. We are exporting our business from Minnesota because government's intervening in the ability of these businesses to be able to make the call and serve the markets that are there. And members, the discussion's been about liquor store owners. What about the people of Minnesota? I would expect Representative Kahn's probably got the numbers. She's got charts and graphs and numbers for this. But poll after poll after poll is in the 50s, 60s, 80%. I don't know how high. I've seen them very, very high. The people of Minnesota want this amendment. Let's vote on behalf of the people. Thank you, Madam Speaker.
The member from Sibley, Representative Gruenhagen.
Oh, thank you, Madam Speaker and members. Yeah, just one quick comment. I have a longtime friend and acquaintance who is a beer distributor, and he says the reason so many people go to Wisconsin is because of the high taxes here in Minnesota. It really doesn't have much to do at all about Sunday sales. So with the ever-increasing taxes on beer sales, we can expect more and more Minnesotans, regardless of whether it's open Sunday or not, to go to Wisconsin to buy their beer or to neighboring states. Thank you, Madam Speaker and members.
Representative Atkins. The member from Stearns, Representative O'Driscoll.
Well, thank you, Madam Speaker. I just have a question to the author of the amendment. If she yield?
She will yield. Representative O'Driscoll.
Thank you. Would your amendment in any way limit the local municipality or county who would issue the liquor license from prohibiting sales on Sunday if they wanted to at the local level?
Representative Liebling.
Thank you, Madam Speaker. Representative O'Driscoll, I don't think so. It would just remove the state prohibition. It wouldn't, I don't think. I can't say I've really examined that. Maybe somebody else can answer it that knows more than I, but I don't think that that would stop a municipality from regulating the liquor within their own borders.
Representative O'Driscoll.
Well, thank you, Madam Speaker. Representative Liebling, the reason I asked that question is generally in the state statute right now, liquor stores can be open from 8 a.m. to 10 p.m. And I know that the cities of Minneapolis and St. Paul have chosen by ordinance, and other cities in the metro area, to dial that back to 8 p.m. And so we've got some liquor stores that aren't even taking full advantage of what the law says, or municipalities dialing that in. Maybe what we should do is send this back to committee and do some committee work on this and look at the broader implications of this.
Representative Liebling.
Thank you, Madam Speaker. Well, Representative O'Driscoll, if you look at the amendment, which shows you what the current law is, current law says that it puts that 10 p.m. limit in there. So I think you just answered the question. That the municipalities apparently are dialing that back to suit their local interests. So I think the answer quite clearly, given you just gave me the answer to your question, which is that this doesn't stop the municipalities from doing something more restrictive within that.
Representative O'Driscoll.
Well, thank you, Madam Speaker, but I think that you've just answered my question, Representative Liebling, because why would we not be on the floor fighting and saying that those businesses shouldn't have the right to stay open until 10 o'clock? When we're saying that we want to change statute right now to allow them to be open on Sunday. It's a public policy issue.
The member from Chisago, Representative Barrett.
Thank you, Madam Speaker and members. I know this bill, this amendment anyway, the subject has been around for a lot of years, and to me I look at it two ways. Opening up liquor sales on Sunday will either increase alcohol use in our state, or it will increase the cost of alcohol for those people that buy it. If it increases the cost, those people that buy it, but doesn't increase sales or use, then it's got to increase the price of the product, because the people that own the liquor stores are going to have to recoup their extra costs by raising the price. So this issue's been around for many years. I think this year it's a little bit different. And it's different in my mind because a couple weeks ago the DFL party jacked up the tax on alcohol in this state by hundreds of millions of dollars. They did that at the same time they said that those who drink alcohol casually will not pay very much because they just don't use enough alcohol to pay for it. Well, hundreds of millions of dollars is a lot of money, so somebody's going to have to pay for that, which is probably going to be the heavy user, the abuser, and the alcoholic. At the same time, in the tax committee, we had people come in, good people from the treatment community who said, yep, we need to do this because we need more money for treatment programs. So they were all in favor of increasing the price, the tax on alcohol. Unfortunately, the bill, the tax bill or the HHS bill, doesn't include any new funding for alcohol drug treatment programs, none. Yet we're still raising the cost of alcohol by hundreds of millions of dollars. Members, that's promises made and promises broken right there. But not to be undone, those people that still want the high alcohol tax want it because $3 billion in our state is used for programs related to drug and alcohol use. And that's a high cost for alcohol use in Minnesota. So now today we have an amendment to a bill allowing liquor sales on Sunday that will increase access to alcohol by 16%. At the same time, you're raising taxes on alcohol without providing any new funding for alcohol treatment or prevention. Brilliant logic, members. Please vote no.
Representative Atkins.
Thank you, Madam Speaker. And for folks that aren't familiar, generally what I've done over the last 6 or 7 years of carrying this bill, I recognize that I'm carrying this for sometimes 10, 12, 15 different members who have everything from the Groveland Tap, Representative Paymar, to the new Bohemia Sausage Factory or Sausage House in Minneapolis, to the Winnebago Brewfest that Representative Gunther is concerned about, to the pizzeria in Representative Sundin's district. What I would ask of you is that you think about the fact that we try to keep this as non-controversial of a bill as we possibly can. Just in the last 24 hours, once the amendment was posted, I see that the Minnesota Family Council, the Teamsters, a bunch of mom-and-pop liquor stores, businesses, mayors, and city council members have weighed in opposition to the amendment. And I think if you check with some of your local folks, that's probably what you'd find. But unfortunately, when we do this by amendment, we oftentimes don't get that opportunity. With that, I'd suggest to you that the appropriate vote on this today is no. And I would suggest that for folks who truly want to see that Sunday sales actually occurs, that there's a better way to go about that. And that is, rather than put up, and I might be assuming something that isn't correct, but I think it's going to go up, and I think it's going to fail by a very wide margin. And you wonder then why I'm reluctant to give it a hearing the following year is because it goes down 110 to 24 or something like that. And that's because it isn't processed in the most appropriate fashion, which is you get organized, you come up to the Capitol early on, you show that there's support for it, you work with both sides to try to work something out, you propose it as kind of a pilot or some abbreviated version or something like that, and you pursue it. But when you pursue it as an amendment on the House floor, and it goes down by a considerable margin, it has much less likelihood of prevailing in the next session. And in defense of those members who have provisions in this bill that are very important to their communities, I would ask that before you vote green on something like this, you give some thought to those 14 members that have provisions in the bill that are very important to them. And in my effort to keep it non-controversial, I'd ask that you oppose the amendment.
Representative Doubt.
Thank you, Madam Speaker. Would Representative Liebling yield for a question?
She will. Representative Doubt.
Thank you, Madam Speaker. And Representative Liebling, it dawned on me as I was listening to the debate here, and I remember just last week, I think it was, that the Democrats in the House voted to increase hundreds of millions of dollars of tax and revenue for the state of Minnesota, basically on beer and liquor sales. Is this a way of trying to pick up even more revenue, squeezing a little more money out of that turnip by allowing us to collect even more tax from those people on Sundays? Is that what this really is all about?
Representative Liebling.
Well, thanks, Madam Speaker and Representative Doubt. I guess whether liquor sales are going to increase or decrease depends on who you talk to about this. That seems to be kind of the question. And Representative Atkins is suggesting a pilot here. Well, I would suggest to everybody that 38 states are already conducting the pilot. There are only 12 that don't allow liquor sales on Sunday. And, I guess it kind of depends. This kind of goes back to Representative Barrett's point, too, about, who's going to be buying more or less or how the tax would be distributed. I would submit that there are people who probably would buy a bottle of wine. They're not the problem drinkers. They're the people who go to the and oops, the store is closed. That's right. Liquor stores are closed on Sunday, and they just forego buying the bottle of wine because they're not big users. So maybe we are missing some tax on people who might just forego getting that bottle of wine or that six-pack of beer because it isn't convenient, and then they just go on and they don't buy the product at all because they couldn't buy it when they were available to buy it. So, of course, this has come up very many times, and this amendment, and of course, the intention is not anything about getting more tax or less tax. I frankly don't believe it's going to change the overall alcohol buying habits of the public that much, but this is about consumers. This is about consumers. So that's the answer to your question, Representative Doubt. I know you're trying to now use this to make a different political point. For me, this is about consumers. It's about letting stores liquor stores operate the same way other retailers operate, and that is they make their own decision for their own business about what days they want to be open. And if they want to go to their local, if their municipality is more restrictive and they think that's the wrong thing, they should go to the municipality and argue their point there. But this to me is about the consumer and the fact that a lot of the consumers who forget that liquor stores are closed on Sunday because they used to live somewhere else, or they just don't think about liquor all the time, and they go and the store is closed and they just forego that bottle of wine because they can't buy it when they're available to buy it. I don't think those people are going to be a big organized lobby, but I think Representative Drazkowski's right that the data really shows that consumers think they ought to be able to buy that bottle of wine when they're available. And if the store wants to close on Sunday, they should be able to go find another store that sells it without having to cross into Wisconsin.
Representative Dowd.
Thank you, Representative. Thank you, Madam Speaker, and Representative Liebling. I appreciate that. I was concerned, at a time in our history here where basically Republicans over the last couple of years turned a $5 billion budget deficit into a $3 billion surplus, and revenues continue to exceed expectations or projections moving forward. Our economy is on the mend, and I'm very glad to hear that this really isn't an effort to increase even more taxes on the hardworking taxpayers of Minnesota. Last week in the House, Democrats voted to increase taxes $2.6 billion in this recovering economy, and another $300 million or a little more than that in additional fees. So at a time where our economy is finally on the mend and recovering because of the policies we put in place over the last couple of years, I'm glad to hear, and I'll glean from your statements, Representative Liebling, that you think that that's enough. And I'm glad to hear that we maybe have finally hit the ceiling, because everybody on this side of the aisle was very worried that there might not be an end to the tax increases and the fee increases that the Democrats are willing to inflict on the hardworking taxpayers of Minnesota. So I appreciate your finally finding what we think is the limit, sad enough as this limit is.
Discussion to the Liebling amendment. Seeing no further discussion to the amendment, the clerk will take the roll. Representative Murphy.
Madam Speaker, I would move those not voting be excused from voting.
Representative Murphy moves that those not voting be excused from voting. All those in favor, please say aye. Aye. Those opposed, please say no. No. The motion prevails. The clerk will close the roll. There being 21 ayes and 106 nays, the motion does not prevail. The amendment is not adopted. There are no further amendments at the desk. The clerk will give the bill its third reading.
Third reading, Senate File 541 as amended.
Third reading. Discussion. Representative Hoppe.
Thank you, Madam Speaker. Well, members, we are doing the Omnibus liquor bill, and Representative Atkins, as usual, did a good job putting it together and keeping it a relatively non-controversial bill. And every year it's full of exemptions for different establishments and different local governments. But I do think this year, and it's been mentioned a couple of times already, but I do think this year that we should again mention the tax issue on Minnesota beer producers. And I think we're looking at an issue where for 10 years we have been carefully helping to bring along a whole industry. And when you look at the number of craft brewers that have sprung up in the state of Minnesota, and the Summit Brewery and the Shells Brewery in New Ulm, and hopefully soon Surly and other breweries that are coming along, I think that the move in the tax bill to tax them, not just tax them a little bit more, but an enormous amount more, I think we're sending the wrong message to our people in Minnesota that are trying to start breweries and trying to grow breweries. I think what we've done has been a good thing. I think the people of Minnesota like it. I think it's good for jobs, it's good for business, it's good for the consumers. And members, I think it's just important to us, whether we voted for this or against this, I think we have to remember what this message is sending to this industry that we've done so much to work on. With that, I appreciate your time, and thank you, members.
Discussion. The member from Brown, Representative Torkelson.
Well, thank you, Madam Speaker. I happen to represent the Shells Brewery in New Ulm. It's the second oldest family-owned brewery in this country. Has an over 150-year heritage and provides lots of jobs in my district. I would speak in favor of the brewery and against this bill. Thank you, Madam Speaker.
Sure. Discussion. Representative Atkins.
Madam Speaker, members, it's a good bill. It's got provisions on behalf of 14 or 15 different communities, and I'd appreciate a green vote.
Seeing no further discussion, the clerk will take the roll on the bill. Representative Murphy.
Thank you, Madam Speaker. I move that those not voting be excused from voting.
Representative Murphy moves that those not voting be excused from voting. All those in favor, please say aye. Aye. Those opposed, please say no. No. The motion prevails. The clerk will close the roll.
Deal.
There being 103 ayes and 24 nays, the bill is passed as amended and its title agreed to.
Madam Speaker.
Representative Murphy.
Thank you, Madam Speaker. I move that the call of the House be lifted.
Representative Murphy moves that the call of House be lifted. All those in favor, please say aye. Aye. Those opposed, please say no. No. The motion prevails. The call of the House is lifted. The next bill on the calendar for the day is House File 947. The clerk will report the bill.
House File 947 on the calendar for the day, a first engrossment, an act relating to human services.
The member from Olmsted, Representative Liebling.
Thank you, Madam Speaker and members. Well, after the excitement of the last bill, this one should be pretty simple. This bill, I've asked to have passed out the House Research Bill Summary, which I think explains pretty well what I'm trying to do here. In March of 2011, we had an OLA report on civil commitment of sex offenders, and one of the suggestions was to separate the statute. Right now we have one statute that deals with civil commitments, which includes civil commitment of people who are committed as mentally ill and dangerous, and also the people who are in the two categories of sex offenders. So in 2011, the legislature, then under Republican control, instructed the commissioner to go ahead and do this, to separate the statutes. And that's what you have before you is the result of those efforts. So the bill is completely technical in the sense that it makes no substantive changes to the law. It simply creates a new section in statute where it puts the civil commitment statutes that pertain to sex offenders and leaves the mentally ill and dangerous sections in where they are now. So this is very technical. If you have questions on it, I can try to answer them, but as you can see from the House Research Summary, the intention is to be completely non-substantive, and there's even language in the bill that makes that very, very clear. So I would ask for your support.
There's an amendment at the desk. The clerk will report the amendment.
Dean moving to amend House File 947, the first engrossment as follows. The amendment is coded A1.
The member from Washington, Representative Dean.
Thank you, Madam Speaker and members. This amendment is simply a technical amendment that corrects two mistakes that are in the bill. One on line 2.2 and 2.3, and the other one on line 9.15 that have incorrect references. These two corrections just simply correct the mistakes that refer to the wrong sections of the bill.
Representative Liebling.
Thank you, Madam Speaker. I do not have a copy, and I was not aware of the amendment. So
we'll bring a copy of the amendment back to you.
Thank you. Madam Speaker, would Representative Dean yield to question?
He will yield. Representative Liebling.
Thank you, Madam Speaker. Representative Dean, I don't believe this amendment made deadline, and I haven't seen it before. So, if it's really just technical, and it appears to be, I don't have any problem with that. I mean, this whole bill is technical, but I would just ask you to explain who brought this to you or where it came from, and also if you could just help me understand why nobody mentioned it to me, that would be helpful as well.
Representative Dean.
Thank you, Madam Speaker. Representative Liebling, just in reviewing the bill, there was just some differences with an earlier version. In fact, I think your version was correct originally. These are just two mistakes that were caught, and they weren't caught until this morning. I want to make sure that we vote on the correct references, and these just simply correct two references that misdirect portions of the bill that miscorrect portions of the bill. On the lines 2.2 and 2.3, secure treatment facility has a cross-reference to 253D.02. However, if you look in subdivision 9, there's a respondent portion. So that's incorrect. The other one is on 9.15, reference to the definition of a word committed person with a cross-reference. Subdivision 4 on line 21.7. However, subdivision 4, the definition is for committing court, not committed person. So those are just two technical corrections that we did not have time to catch in time for the 24-hour rule, but we just wanted to make sure that we're voting on the correct language.
Representative Liebling.
Well, Madam Speaker, Representative Dean didn't explain who found this or why nobody spoke to me about it, and so I guess, and it did not make the pre-filing amendments, or a deadline, Madam Speaker. So if there is a technical problem in the bill, I certainly would like the opportunity to fix that problem. So I guess, Madam Speaker, I would request that if we could temporarily lay over the bill so that I could get an opportunity to examine the amendment and see whether this is indeed something that I agree with.
Representative Liebling will lay over your bill temporarily and take up the next bill on the calendar for the day. The next bill on the calendar for the day is House File 1120. The clerk will report the bill.
House File 1120 on the calendar for the day.
The member from Hennepin, Representative Freiberg.
Thank you, Madam Speaker. This bill was brought to me by the Office of Administrative Hearings. In 90% of cases that the Office of Administrative Hearings hears involving state agencies, OAH makes a recommendation, but the agency head renders the final decision of the agency. In 10% of the cases, however, the administrative law judge, or the ALJ, issues the final decision on behalf of the agency. The statute governing appeals of agency decisions doesn't distinguish between these cases, however, and says that the agency is listed as the party in the case. In the case of those 10% of cases where the ALJ issues the final decision, this means that the Office of Administrative Hearings itself is treated like a party in the case. This would be similar to a judge being listed as a party in the appeal of a court decision, and it's potentially awkward for the judge to be arguing that his or her decision should be upheld or not be upheld, presumably. This bill would change law so that these cases are treated the way most cases are treated, and the real party with a policy interest in the decision, in this case the state agency, is the party who has served the appeal. This bill was heard in 2 committees and was not controversial. I urge a green vote.
There is an amendment at the desk. The clerk will report the amendment.
Fabian, moving to amend House File 1120 as follows. The amendment is coded A1.
The member from Roseau, Representative Fabian.
Thank you, Madam Speaker. We're waiting for the amendment to be handed out to members.
Representative Fabian.
Thank you, Madam Speaker. I appreciate your indulgence. Just wanted to make sure that everybody could read along here. What the A1 amendment is going to do is it's going to help the small business owner, I hope. Small businesses obviously are defined by in law, and what we would like to be able to do, what I would like to be able to do is help them out in cases where they are found with the administrative law judge, where they are found to be substantially justified or substantially correct. It would allow them the opportunity to be able to collect their legal fees and so forth. So let's just say that there's a situation where a small business owner is fined by a state agency for a violation that might be with regards to some sort of a maybe on a farm where they've got a manure pond or something, and MPCA finds out that they don't have it quite to standards, and they do go to a hearing and they find out that the fine is too large and the administrative judge sides with them. It simply allows the small business owner an opportunity to recover their legal fees. This is for the little guys out there. This is for the small business owners looking for a little justice for them. So I'd appreciate a green vote. Thank you.
Representative Freiberg.
Thank you, Madam Speaker. I did have the opportunity to speak with Representative Fabian about his amendment. I understand in general what he's trying to accomplish, but I have some concerns with the timing and the potential costs to this. This is apparently based on a bill that was heard in the previous session, but a bill has not been introduced this session, so I haven't had the opportunity to speak with those who would be most impacted by it, business owners, state agencies, and so forth. Beyond that, the bill from the last session had a $6 million cost, and I don't know where those funds would come from. I should mention, have had a chance to speak with one state agency, in this case the MPCA. I know they had some pretty serious concerns with the bill. They mentioned, or with the amendment, they mentioned, for example, I'll just read from this here. The proposal is troublesome because of how it changes the threshold for potentially awarding attorney fees to include situations where businesses are still found to violate workers' safety, families' financial securities, public health, or natural resources protection. Current law already contains long-standing protections for small businesses if a state agency is not able to prove its case that the business violated state law. However, under the bill, a business no longer has to prove it was not in violation to be awarded expenses. If enacted, a business only needs to have the terms of the penalty be reduced to be able to seek reimbursement for their attorney's fees and other costs. In other words, they would still be at fault. The fine would just be a little bit less. The amendment's language also expands current law beyond monetary penalties to potentially include other situations where the state has made a demand. It would expand the law to potentially affect the initial demands by an agency for a business to stop an illegal activity or take a corrective action to repair the harm done if that demand were to be challenged later as excessive. I don't know that I agree with every point they've made, but I don't know that I disagree either. Just in short, I feel this is something that needs a little bit more discussion. I'm happy to continue the discussion with Representative Fabian, but in the meantime, I would urge a red vote.
Representative Fabian.
Thank you, Madam Speaker. Well, it's my understanding that there is no cost to the agency. It goes through the Attorney General's office. And in terms of this budget cycle, this biennium, if you look on line 2.18, the effective date is August 1st of 2015. And with that, I would request a green vote, Madam Speaker, and I'd also like to roll call this. Thank you.
Representative Fabian requests a roll call. Seeing 15 hands, there will be a roll call. Discussion. Representative Pepin.
Thank you, Madam Speaker and members. Members, I strongly encourage a yes vote on this, a green vote. This is a small business vote. You know, the agencies do great work, but there are times when maybe they overstep their bounds just a little bit. And there are several examples of small businesses that have had to pay when maybe it's been one of those times where the agency has overstepped its bounds. And this simply says, you know, we ought to be able to recover those attorney's fees when a judge has found that they're really not at fault. So, members, I strongly encourage that if you are in support of small businesses, that you vote green on this amendment.
Discussion. Representative Fabian.
Well, thank you, Madam Speaker, and thank you, Representative Pepin, for pointing that out. That is obviously a situation. Members, this is an opportunity for you to vote for the little guys. You can either vote for big government, who maybe comes along and in good faith maybe decided that they were going to issue a fine, but it was found out that the fine is excessive, and the agency is now told that, no, you were excessive. And you're going to allow the little guy an opportunity to defend themselves in front of the administrative law judge and give them a chance to collect their legal fees. These things are extremely expensive for them to contest, I'll say, and I think in a lot of cases maybe some agencies just hope that the little guys will just roll over and pay the fine, maybe negotiate it down. But in some egregious cases that have happened, this is an opportunity for us to side with the little guys. This is an opportunity for us to give a little justice to them and tell government you got to watch your P's and Q's just a little bit more. For me, this is a common sense bill. It's based on what we do a lot of in rural Minnesota, and I urge a green vote. Thank you.
Discussion. The member from Dakota, Representative McNamara.
Thank you, Madam Speaker. Madam Speaker, I'm wondering if the author would yield for a question.
The author of the amendment or the author of the bill?
The author of the bill. I'm sorry, Madam Speaker.
The author of the bill will yield. Representative McNamara.
Thank you, Madam Speaker. Representative Freiberg, I'm reading this, and Representative Fabian has mentioned how it'll help the small business owner, but I remember you specifically mentioned MPCA, and I remember having a constituent who had a problem with the agency, and the agency had made a mistake, and I think it certainly was along these lines of substantially in excess of the final decision, unreasonable under the facts. But Representative Fabian talks about helping out a small business owner. I believe this bill would also help all Minnesotans out. If an agency overreaches with a constituent to the extent that that Representative Fabian is establishing here, it would protect our citizens against overreach. Sometimes our agencies overreach and think they are not responsible. Wouldn't this help our constituents out also if this happened to them, not only a business owner?
Representative Freiberg.
Thank you, Madam Speaker, and Representative McNamara. You may be right. That, to me, would be an argument that this should be vetted more in committee. Again, according to the MPCA, and again, this is the only agency I've had the time to interact with on this issue, current law already contains long-standing protections for small businesses if a state agency is not able to prove its case that the business violated state law. If a court finds that the state has not prevailed in proving its allegations against a small business, the court may choose to award costs, including attorney fees, which this bill deals with, and other approved expenses that were incurred to rectify the situation. I would just say that this is something that should be discussed more in committee. Bill was not introduced and no hearing request was made.
Representative McNamara.
Thank you, Madam Speaker. Well, Representative Freiberg, I think you answered my question as I thought was the situation with the facts. This is something that will help all Minnesotans. Unfortunately today, as you acknowledge, the agencies don't like this. No, they want to be able to way overreach and not be held responsible for it. This standard is substantially in excess of the final decision and was unreasonable under the facts. If the agency does that, all we want them to do is restore this constituent or the citizen what was taken away from them. Maybe they had to go hire a neighbor attorney down the street and had to pay him $800 or $1,000 or $10,000 or whatever. There's too high of a standard today. This is still a very high standard, and I just think, members, please support the Fabian amendment.
Representative Fabian.
Thank you, Madam Speaker. And to Representative McNamara's point here, in law it states that substantially justified in one case, for example, justified to a degree that could satisfy a reasonable person. Now, being from rural Minnesota, greater Minnesota, northwest Minnesota, what's reasonable to a small business owner out there in the real world may not be reasonable to employees of an agency that are here in St. Paul. And hopefully, if the case is decided by an administrative law judge that the small business owner has been reasonable and the agency has been unreasonable, we can take care of their legal fees and other things associated with this. Please vote on the side of reasonableness. Vote green.
Discussion. Seeing no further discussion, the clerk will take the roll on the amendment. The clerk will close the roll. There being 58 ayes and 69 nays, the motion does not prevail. The amendment is not adopted. There are no further amendments at the desk. The clerk will give the bill its third reading.
Third reading, House File 1120.
Third reading. Discussion. Seeing no discussion, the clerk will take the roll on the bill. The clerk will close the roll. There being 111 ayes and 16 nays, the bill is passed and its title agreed to. The next bill on the calendar for the day is Senate File 887. The clerk will report the bill.
Senate File 887 on the calendar for the date of fifth engrossment, an act relating to health.
The member from Anoka, Representative Laine.
Thank you, Madam Speaker. This is the Department of Health's policy and technical bill, and it has three main policy parts. I would just like to go through those three. The first one is radon. A number of us know that radon needs more public awareness because it's a serious health concern. Radon is colorless, odorless, and a radioactive gas that breaks down in the soil and seeps up from the earth. The problem is that it seeps into our homes and concentrates there. Long-term exposure can cause lung cancer. It's the second leading cause of lung cancer. At least 1 in 3 homes in Minnesota have radon levels that pose a significant health risk. But at-home tests are easy and inexpensive, and remediation can be as low as $800, averaging about $1,500. So the Department of Health is seeking education and awareness of radon through the 40,000 home sales that we have in Minnesota each year. Information about radon will be disclosed through a handful of questions, and information will be given out explaining the serious need to test. There's no testing mandated, and there's no mitigation mandated. The wording of the disclosure has been worked out with both the realtors and the State Bar. And I will remind you that Representative Paul Anderson had a bill similar to this introduced this session. The second area has to do with background checks for a small group of individuals who volunteer to help in state emergencies. We have what's called Minnesota Responds, a group of volunteers trained in emergency and disaster response. A smaller group of them are the mobile medical and behavioral health teams. Since these volunteers, and there's only about 100 in this group, are working often unsupervised with vulnerable adults and children, the department wants to be able to do a background check. The third area in this bill has to do with body art. To protect the public from blood-borne diseases and infections, the Department of Health began licensing body art technicians a few years ago. Today we have about 800 licensed technicians, and they joined the department in wanting better regulation over unlicensed body artists. So the department is moving to make it a gross misdemeanor to practice unlicensed. This body art bill ran separately in the House with Representative Isaacson. Madam Speaker, would Representative Isaacson yield?
Where is he? He will yield. Representative Laine.
Representative Isaacson, would you please share a little about what you learned when you carried the body art bill?
Representative Isaacson.
Madam Speaker, Representative Laine, it's pretty simple. The idea is we're finding there's a lot of folks out there that are conducting both piercings and tattooing in an unsafe way, and that we're seeing that the licensed or established body art folks in Minnesota really want to see some sort of regulation to ensure that there are safe and healthy and quality products being done in terms of piercing and tattoos, and so the concern is that they needed to put some teeth into this, and one of the things they did was to make it a gross misdemeanor in an effort to find a way to hopefully deter or at least provide some punishment for those that break the law. Thank you.
Representative Laine.
Thank you, Representative Isaacson. And the Senate ran these two bills together, and so we have it before us today in the Senate file. And I would also acknowledge that Representatives Swedinski did a bill similar to this year. So the rest of the bill is pretty much technical, and Madam Speaker, that's the bill.
There's an amendment at the desk. The clerk will report the amendment.
Laine moving to amend Senate File 887, the fifth engrossment as follows. The amendment is coded A1.
Representative Laine.
Thank you, Madam Speaker. This amendment is one last technical fix that the Senate forgot. Please vote green.
Discussion to the amendment. Seeing no discussion, all those in favor, please say aye. Aye. Those opposed, please say no. The motion prevails. The amendment is adopted. There's another amendment at the desk. The clerk will report the amendment.
Dean moving to amend Senate File 887, the fifth engrossment as follows. The amendment is coded A2.
The member from Washington, Representative Dean.
Thank you, Madam Speaker and members. This again is just a technical correction. Would refer members to page 4 of the bill, line 4.3. In line 5 refers back to a section on the previous page, which is subdivision 2 in definitions. It appears that it should, in fact, relate to a different portion of the bill. It's a mistake. Again, what the amendment does is it simply corrects the technical mistake within the bill. Rather than submit another correction amendment, what I would like to do is withdraw the amendment and move a referral of the bill back to the Rules Committee, and I would rise under House Rule 3.34, referral for corrections. And I would ask for a roll call.
Representative Dean moves to move the bill back to committee and requests a roll call. Seeing 15 hands, there will be a roll call. Representative Murphy.
Thank you, Madam Speaker, and thank you, Representative Dean. And I've been studying the rule about technical amendments, and Representative Dean's amendment, as I looked at it on this bill, is a technical amendment. We spoke with the reviser, and we understand it to be a technical amendment. And while Representative Dean is withdrawing the amendment, it's certainly something that Representative Laine could offer to correct the bill and let the bill move forward. And so I think that if we're interested in making sure the bill is in the right order, there's a means to do that without sending it back to committee through re-referral, and therefore I oppose the amendment.
Discussion.
The motion. Excuse me, Madam Speaker,
Seeing
the motion.
No further discussion, the clerk will take the roll on the motion to re-refer the bill back to committee. The clerk will close the roll. There being 56 ayes and 71 nays, the motion does not prevail and the bill is before us. Representative Dean withdrew his amendment. There is an amendment at the desk. The clerk will report the amendment.
Laine moving to amend Senate File 887, the fifth engrossment as follows, and the amendment is coded A2.
The member from Anoka, Representative Laine.
Thank you, Madam Speaker, and thank you, Representative Dean, for finding this. It's proper, and I support this amendment.
Discussion. Seeing no discussion, all those in favor of the motion, please say aye. Aye. Those opposed, please say no. The motion prevails. The amendment is adopted. There are no further amendments at the desk. The clerk will give the bill its third reading.
Third reading, Senate File 887 as amended.
Third reading. Discussion. The member from Hennepin, Representative Pepin.
Thank you, Madam Speaker. Would Representative Laine yield to a question?
She will. Representative Pepin.
Representative Laine, I'm looking at the loan forgiveness section, and it looked like you you crossed out an affidavit and added a confirmation of practice form. Could you talk a little bit about the loan forgiveness program and then explain that change a little bit?
Representative Laine.
Thank you, Madam Speaker. It's very simple little change. It was too arduous for the people to have to go through the process that was listed in the bill, and this just makes it very easy for them to move it forth. I will have to look in my notes to find more than that, but I do remember that it was a simple little change that the department found acceptable, workable with the people who were needing to do this work.
Representative Pepin.
Madam Speaker, would Representative Laine continue to yield?
She will. Sorry, allergies. Representative Laine will yield. Representative Pepin.
Thank you. Representative Laine, I would like to get the answer to that. What I'm really specifically wondering is, I'm not really sure what a confirmation of practice form is, and I don't know if that is, did you need a notary for that, or I don't know what that is. And the reason I ask is because if this is a loan forgiveness program, I believe the loan forgiveness program is where some are given their loan forgiveness for school for meeting certain qualifications. I know in the M&A bill that we just passed, which I think is different than this, we gave loan forgiveness basically for as soon as a nurse graduated from school, and he could get loan forgiveness within 6 months with basically no additional requirements. This, I think, might be if it's working in a rural area or something, but I'm not sure that I want to lessen the standards by not having them have a legal document formed, because I think if they're just bringing in a piece of paper and they're just saying, yeah, trust me, that's not good. I don't know if that's what this is, which is why I'd like to know the standard between an affidavit and a confirmation of practice form. I'd like to know which one is the more stringent, and if the confirmation of practice form requires a notary to sign off, or how that compares.
Representative Laine.
Thank you, Madam Speaker. It is a Department of Health loan forgiveness program, and the current statute requires participants to annually provide the department with an affidavit verifying they are working in the area or facility that they agreed to work in to receive the loan forgiveness. This level of documentation is cumbersome for the participants and unnecessary for the Department of Health's verification. By changing the word affidavit to confirmation, the needs of the program are met without diminishing oversight.
Representative Pepin.
Thank you, Madam Speaker. Would Representative Laine continue to yield?
She will yield. Representative Pepin.
Thank you, Representative Laine. I'm wondering if, seems like you're not sure on the answer. I really, before I would vote on this, would really prefer to know whether or not there's, an affidavit, you have to have that notarized, and you're saying, yes, I confirm, and I confirm to you, and a notary has to sign it, saying that you're saying it in front of them, and it's a legal standard. But I don't know what a confirmation of practice form is. If you could specifically find out, is there any requirement? What the definition of that is there any requirement that a notary sign off on it? It may be cumbersome, but when we're talking about loan forgiveness, that's quite a benefit. I think that we should have cumbersome, perhaps. So I prefer whichever standard is stronger, and it sounds like if the department feels it's cumbersome, they feel like the confirmation of service or practice form is less stringent, but I don't know that that's the direction we could go in. Perhaps maybe you could talk to staff about it as other people ask questions and find out. I'm just trying to figure out which is more stringent.
Representative Laine.
Thank you, Madam Speaker. It's amazing to me that I went through every single part of this bill upside down and backwards so that I could be able to answer any question, and this one I can only answer to the degree that I have done so. But I do remember being told that they are in the program and they have to repeatedly verify that they are still there. And so that they would have to notarize it again and again and again when they can just simply have somebody who is, for instance, the dean of whatever, somebody at wherever they are, some authority that they are working for, confirm that they are still there. It makes it simpler, easier, but it is definitely acceptable, and it doesn't diminish their oversight.
Representative Pepin.
Thank you, Madam Speaker. I'm wondering if Representative Liebling might yield to the same question, because I know Representative Liebling is an attorney and she's also the health policy chair. So maybe she could clarify on this confirmation of practice form and whether or not that has to be notarized and how that differs from an affidavit. Would Representative Liebling yield?
She will not. Representative Pepin.
Well, thank you, Madam Speaker. I guess I'll just express some frustration with not being able to have a question answered that was in the bill. Thank you.
Discussion to the bill. Representative Holberg.
Thank you, Madam Speaker. Will the author yield?
Representative Laine will yield. Representative Holberg.
Thank you, Madam Speaker. And Representative Laine, I don't remember which committee I heard this bill in, but I expressed a concern about people that had radon tests decades ago not being able to find the form, and even whether or not the tests of 20 to 25 years ago were as valid and calibrated the same as more recent tests. And I'm wondering if you had any more discussion about that, and if this bill is going to conference, or if we're just stuck with the language that's in the bill.
Representative Laine.
Madam Speaker, thank you. The disclosure form at the time of sale has some questions like, have you tested for radon? And yes or no. And do you have the paperwork to verify what that was? Yes or no. So there's no requirement that you have it. There's no requirement that you do it. You have to disclose, if you have it, that you have to either have it before you or hand it to them, which would be, hey, this is 20 years old. They could see for themselves. No, I don't have it. I lost it. That's perfectly a part of one of the answers you could give. It's just yes or no. The person who is buying the house needs to be able to have access to this information. You could only give them the information you have.
Representative Holberg.
Thank you, Madam Speaker. And will the author yield?
She will. Representative Holberg.
All right, thank you. For follow-up, did you do any research as to the validity of tests 20 to 25 years ago, and whether the calibration was the same? Does a reading of a 4.2 and a 25-year-old test equate to the tests that are done now? Do you have any research on that?
Representative Laine.
Thank you, Madam Speaker. I don't believe it's so much the calibration as it is the fact that things change in the ground, in your house. Even seasonally it changes. So the recommendation is actually to take tests across season. If you do one test and it's high, take it in the next season, because when you have the windows and doors open more, you'll have a lower reading. So it's less important that it was a particular reading in the past, because I would imagine the calibration would be very similar. But the point is that you do it over time to find out what your average is in that house over the year.
The member from Pope, Representative Anderson.
Thanks, Madam Speaker. I appreciate the language brought forth in this bill. Thanks to Representative Laine. Anything we can do to increase the awareness, I think, is good. I do have a question. Would the author yield to just a question on some language?
She will. Representative Anderson.
Representative Laine, on page 5 at line 13, you talk about a buyer who is injured by a violation of this statute. Just what is meant by the term injured?
Representative Laine.
Thank you, Madam Speaker. As I recall in this, the liability that was written in legally to make sure that we're not making it a problem for the buyer, for the seller of the house years later, is a 2-year period of time in which a person who feels they've been harmed by the lack of material disclosure of the information about radon can actually go back to the seller for cause. I don't think actually radon is going to cause a problem in you within a 2-year period of time. So there is that 2-year period of time limit. But it is if they haven't disclosed it, the material information that they had about radon in the house, and the person feels that they have been harmed by it within that 2-year span.
Representative Anderson.
Thanks, Madam Speaker, and thanks, Representative Laine. That was my concern. If we're talking about the actual onset of lung cancer, that's probably not going to occur within the first 2 years of the home's transfer. So thank you for clarifying that. Thanks.
The member from Wabasha, Representative Drazkowski.
Thank you, Madam Speaker. I wonder if the author would yield.
Representative Drazkowski, did you ask Representative Laine to yield? She will. Representative Drazkowski.
Thank you, Madam Speaker. Representative Laine, is this completely an agency bill, or did you write part of it, or is this, I'm reading some of this, it looks to me like once again we have a bill where government is essentially writing our statutes. I'm somewhat troubled, but wondering if you had a hand in crafting the bill or if it's strictly written by the agency.
Representative Laine.
Thank you, Madam Speaker. This is an agency bill, and they have worked with stakeholders along the way. They have certainly worked with stakeholders along the radon part.
Representative Drazkowski.
Thank you, Madam Speaker, and thank you, Representative Laine. As I suspected, Representative Laine, if you look on, there are exceptions to the onerous radon regulations that are put in here. And by the way, members, if you're not reading the bill, we are putting a new requirement for disclosure on home sales in here, requiring radon testing, including, get this, requiring that the seller provide the buyer with a copy of Minnesota Department of Health's own publication entitled Radon in Real Estate Transactions. That's in the bill. So the government is not only writing the bill, writing our law and further telling Minnesota what they need to do, but they're also creating a market for their publication. But the most alarming part in here, or, well, it's all alarming, but the part that really stands out that is notable is the fact that they exempt sales of homes to the government. So if you're the government, you don't have to be involved in radon testing. Only the private sector does, but not the government. So the government writes the bill and exempts themselves and runs it through here like we've seen, members, many bills before, for us to write in a statute so they can continue to grow their tentacles out and control the people of Minnesota. Very struggling, very alarming section, members. Madam Speaker, wondering if the author would yield once again.
Yes. She will. Representative Drazkowski.
Thank you, Madam Speaker. Representative Laine, the body art section, sections 24, 25, 26, maybe additional sections too in the bill, but those three for sure do grab my attention. And one of them requires actually, and members, if you look at the history of this particular section and statute, and I do remember it, prior to 2010 there was nothing in statute that said we had to do anything about body art in Minnesota. People who wanted to practice a body art business, practice a body art business. I don't know that anybody's died from body art efforts in Minnesota by the businesses that we have. And Representative Laine, if you do know of somebody who's died from body art, please correct me. But members, that was 2010. We're in 2013, 3 years later, and this bill is creating a gross misdemeanor if somebody practices body art and is not licensed. That's 1 year in jail and a $3,000 fine for practicing body art. Something that 3 years ago there wasn't any reference to statute about it. So Representative Laine, I would ask, it's alarming to me, and I'm wondering about the fiscal impacts of that, but are there any other criminal penalties that we introduce in this bill beyond this one?
Representative Laine.
Thank you, Madam Speaker. No. You have asked me several things or mentioned several things here, so I'm going to kind of go through them all. Starting with this body art piece, we regulate things that cause serious harm, serious health harm, not just death. So, however, you could actually get HIV/AIDS through this working with the blood in this situation if the person wasn't clean. So I suppose that could eventually result in death. However, the point is that if it's going to cause a serious public harm, we're going to regulate the area. And the licensing started as this whole thing has picked up, and you're probably very aware that this whole area has picked up in the public arena much more strongly in the last handful of years, and hence comes regulation, and hence comes some way to enforce that regulation. So this is very natural. They've had 3 years to get licensed. They have 3 years to bring it up, and those who are doing it, those 800 body artists who are doing this, want this to have a little more teeth in it. If you watched Fox 9 News was it just yesterday, doing a 9-minute expose on this area, you would have seen some of the situations where people will do it out of their car, do it out of their trunk, do it out of in somebody else's home, do it in their kitchen, totally unclean areas, and so you want these people licensed. You don't want your son or your daughter going to somebody that's not licensed, and that has to have some bite. Now, the bite means that has a gross misdemeanor. It doesn't take just the one person at the Department of Health that has to go around and do all this follow-up, but it can be turned over to the local authorities, and they can decide, they can make the choice whether they want to prosecute further. And those fines you listed are up to, they don't have to go that high. So there's all kinds of room to move there, and we want more bite in that legislation. You talked about the radon. There are several disclosures that are made at the time of a house sale. All kinds of environmental things have to be listed. Does this house have mold? Various things have to be disclosed to the buyer. The buyer needs to know these things. So this is just one more thing that has been on that list all along. It has said, do you know if this house has radon? And have you tested for radon, I think is what it actually says, and you say yes or no. That's what's in there right now to this day. But that's insufficient because it makes people actually not test, not find out, because they don't want to mess anything up. But we need people aware of the serious thing we have about radon in the houses. So we're making it 5 questions. Do you know? Have you tested it? Do you have the paperwork from that testing? Have you done any mitigation? Do you have the paperwork that goes with that system? Simple questions, yes or no. Isn't mandated to do any testing, doesn't mandate that you have to do any mitigation, but people who buy the house have a right to know. And the brochure that comes from the Department of Health is a wonderful brochure. The realtor simply hands it to the person along with the other things that the realtors are handing them in this disclosure. This brochure encourages people to have their home tested. This is wonderful, this is important, and this is very timely.
Representative Drazkowski.
Thank you, Madam Speaker, and thank you, Representative Laine. I did view the video. Thanks for sending the link. And what we saw in there is something that's typical of what we have when we have government get involved in licensing a particular agency. It's called fencing. Members, it's fencing. And what that means is if you're into the business and you're highly invested into the business, you're in favor of licensing because you draw up fences around you that makes it harder for the competition to get in. It creates and captures a marketplace for you that other competitors cannot compete with. And that's what this is, members, fencing. And this is another example led here by our state government through a bill that they brought and wrote. Very, very troubling. And Representative Laine, I mean, if we look at houses, we could figure out all kinds of things. Maybe we need a bat inspection license. Maybe we need to inspect for bats because, by the way, bats carry rabies and somebody could die from rabies. Oh, but our government hasn't brought that yet. That might be coming in next year's bill. So members, be ready. We might be having requiring a bat disclosure. So you have to go around and interview, excuse me, not interview, but you have to go around and count and inventory the bats in your property, and not to mention those in the garage. But members, I find it very alarming that we have here a bill brought forward by our state government multiple sections to the bill, at least two of them that are very alarming. This one that is going to kill business in Minnesota. Another war on work here in Minnesota, members, is the body art provision here that is going to chase body art people in Minnesota out of business. More war on work brought forward by the government that is initiating that war. And it's interesting, the part that's missing from this bill that's equally alarming, if we're truly worried about body art being a health hazard and something that could be detrimental to the health of people in our state, why are we not licensing abortion facilities in Minnesota? Why didn't the government come forward with an abortion facility license provision in this bill? It's eerily missing from this bill. We're going to require licensing and criminal penalties if you're not licensed for body art, but killing babies in this state doesn't require licensing and inspections. So, members, a solid no on this bill. Our government is driving the ship here again, as they have on many bills that have come through this legislature. There's cause for alarm, members, on what's happening. Is it the people of Minnesota that are speaking here, or is it the government that's speaking here? And members, this bill is the government speaking. I encourage a red vote.
The member from Lyon, Representative Swidzinski.
Thank you, Madam Speaker. And just to chat a little bit about Section 11, the penalty for tattoo artists and the licensing, that actually was Representative Drazkowski, a bill that was advanced and forwarded and asked by a constituent of mine. It's House File 1207, which actually was dropped within seconds of the department's bill, and that was brought forward. We had a situation in southwest Minnesota where we did have some practicing tattoo artists where they had folks that were unlicensed coming in, and we did have a number of people being infected and having serious health issues because of a situation that was occurring by folks that weren't necessarily following the rules when it comes to some of the things set forth through the Department of Health and the care that they need to take with some of their equipment. And so it was not exactly it was actually brought forward by a constituent of mine to my attention. And then would Representative Laine take a question?
She will yield. Representative Swidzinski.
Thank you very much. Just looking back towards some of the repealing language moving forward, I've got some information about tattooing of minors. If you could explain that portion of the repealer portion, I may be misunderstanding some of the language, but does this get rid of that portion where parents need to be notified of a tattoo before the age of 18, or am I reading that incorrectly?
Representative Laine.
Thank you, Madam Speaker. I'm sorry, I don't know what you're referring to.
So I've got the bill.
Representative Swidzinski.
Thank you, Madam Speaker. Just looking at 4R of the repealing section of the bill, we've got, I believe, the agency's repealer language to get rid of that. It'd be under subdivision 4(1). That'd be the last one, section 609.2246, the tattoos for minors.
Would you like her to yield?
Yes, Madam Speaker.
She will yield. Representative Laine.
Thank you, Madam Speaker. I'm being told that this is a section that is duplicative. It's in the body art section so that it doesn't need to be here. This is what I'm told.
Representative Swidzinski.
Okay, thank you, Madam Speaker. With the then also looking if the author would also yield to another question.
She will. Representative Swedzinski.
Thank you, Madam Speaker. Just looking at subsection 4, we have some language on the athletic training portion of the bill, and would you want to talk a little bit about that and what that's going to mean to athletic trainers throughout the state? Thank you.
Representative Laine.
Thank you, Madam Speaker. Actually, as the bill was moving through, there was an attempt to put in something for the athletic trainers. It came out of our bill and it came out of the Senate's bill. When the Senate took it out, they forgot to take out one extra piece, so this is repealing the piece that they forgot to take out.
Representative Swedzinski. Discussion. The member from Anoka? Representative Runbeck.
Thank you, Madam Speaker. Would Representative Laine yield for a question?
She will. Representative Runbeck.
Thank you, Madam Speaker. Representative Laine, I'm just reading the bill here and finding lots of references to implementing a comprehensive tuberculosis infection control program. And of course, you know, in large institutions, that makes a great deal of sense. There's some guidelines that we're incorporating that come from the Centers for Disease Control. But Section 16, Representative Laine, makes that same requirement of home care providers. And it would say that this comprehensive tuberculosis infection control program must apply to every paid and unpaid employee, contractor, student, and volunteer. And I'm just wondering what the definition of home care provider, because you could be, I mean, if we're talking little 2- and 3-person businesses, you know, how informal is a home care provider in this context?
Representative Laine.
Thank you, Madam Speaker. This is truly a technical piece where the CDC actually has standards for industry best practices, and as I understand it, Minnesota is actually practicing these at this time. However, the statute has not been updated to reflect these practices, so it's just updating it in our statutes.
Representative Runbeck.
Madam Speaker, if I could, though, Representative Laine, if you'd yield, if you could describe for me what a home care provider is that a very official, precise definition in state law in this case?
Representative Laine.
Thank you, Madam Speaker. No, I can't tell you that. I just know that this is just a technical change.
Representative Runbeck. Seeing no further discussion, the clerk will take the roll on the bill. The clerk will close the roll. There being 79 ayes and 47 nays, the bill is passed as amended and its title agreed to. At this point, we'll revert on the calendar for the day to the Liebling bill. The clerk will report the bill.
$947 on the calendar for today, the first engrossment, an act relating to human services.
The member from Olmsted, Representative Liebling.
Thank you, Madam Speaker. And members, thank you for your patience. If you recall, this is just the reorganization of the civil commitment statutes, a technical bill, and we were on the Dean amendment to my technical bill, which was a technical amendment. And I had the opportunity to speak with the reviser, and she believes that the amendment is not exactly correct. But I do want to point out, so I would ask members, I would ask Representative Dean to withdraw the amendment because the reviser believes it isn't exactly correct. And if you look at the bill, members, there is, in Section 22, there's a renumbering of the entire bill, of the sections. And there's also a reviser's instruction that asks the reviser to renumber the sections, and then it also says the reviser shall also make necessary cross-reference changes in Minnesota statutes and rules consistent with the renumbering. So where we have a technical amendment that the reviser can't tell me is absolutely correct, what she does know is that she doesn't need this amendment to be able to make sure that the bill is consistent. So while I appreciate Representative Dean's attention to the detail here, I think this is maybe just a little bit beyond us, and we should really leave the internal correction to the reviser. And so I'm going to ask Representative Dean if he would withdraw the amendment and just let the reviser do her work as it says in the bill, or if not, I would ask members to vote no on the amendment.
Representative Dean.
Well, thank you, members, and Representative Liebling for that. I think we see, again, some of the issues that we have with the rules that we have to operate on in the House of Representatives. These are the reasons that we want to be able to correct bills on the floor with amendments that we no longer can do. I wish we could have said that we can do that. We can pass legislation. I don't want folks on either side of the aisle to have to vote on legislation that we know is incorrect. It is true that the reviser can correct things, we can make amendments, we can go to conference committees, but we should know very precisely what we're voting on, and that we're not voting on things that are incorrect. I think that if we vote without putting this amendment on, we're saying it's okay to vote on things that are incorrect, hoping that it'll get caught down the line. Representative Liebling, and Representative Liebling, I'm not really on any conference committees or anything. I've got some extra time to look at the bills. I'm happy to do so. Didn't catch this one until this morning, but I think what we're seeing is the reason that we want to be able to correct things on the floor is so that we're not asking each other to vote on bills that we know are incorrect. So that's why I would support the amendment and ask that we would vote it on.
There's an amendment at the desk. The clerk will report the amendment.
Dean moving to amend House File 947, the first engrossment as follows. The amendment is coded A1.
Representative Dean, did you want to speak to your amendment, or did you just do that? Representative Dean.
Madam Speaker and members, I think we've spoken to it already.
Representative Liebling.
Well, thank you, Madam Speaker. And Representative Dean, I just want to remind you and the body that I didn't support the rules that we have. So, you know, I could kind of agree with you that, but the rules do allow us to make technical amendments. So if your amendment was in fact correct, if the reviser had just said to me, yes, that's correct, I overlooked it, go ahead, I would be asking the members to accept your amendment. And so I think the point is made that we don't want things to go through that are incorrect, but sometimes our own technical amendment on the floor can also be wrong, which this one is, as I understand it. So, again, I certainly think it's great if members want to, go over bills with a fine-tooth comb. I think that's very appropriate. It would also be nice if you're going to bring a technical amendment, I think it's courteous and serves good process to speak to the author first, so that we can in fact determine if we agree that the technical amendment is correct. So that would have been nice in this case. But again, I would ask Representative Dean to either withdraw the amendment or ask members to vote no.
Representative Dean.
Thank you, Madam Speaker and Representative Liebling. I apologize for not discussing this with you ahead of time. We just caught it this morning and had it drafted immediately, so I apologize for not finding you and tracking you down ahead of time to let you know that that would be coming, so apologies for that. With that, members, I would ask for your support.
Seeing no further discussion, all those in favor of the amendment, please say aye. Aye. Those opposed, please say no. The motion does not prevail. The amendment is not adopted. The clerk will give the bill its third reading.
Third reading, House File 947.
Third reading. Representative Abler.
Thank you, Mr. Speaker and members. And except for this possible little glitch in the bill is meant to be just a way to rewrite this section of law, and that's the full intent. I just want to caution members, though, as we go forward through this session into the next, that there are some challenges looming on this topic of sex offenders and how we go about treating them and how effective that is and where they wind up and how long we keep them. And I know it's controversial. I'm not going to drag this topic into that now except to bring it up, but it's not nothing. This bill is pretty much nothing in terms of any future work. It makes it cleaner to amend it later so people understand better what work we're doing. With that, I urge members to vote yes.
Discussion. Representative Dowd.
Thank you, Madam Speaker and members. Obviously, I think everybody understands that there are some technical problems with the bill. Representative Dean brought an amendment that he believed would fix those. The bill author thought that there was some technical problems with the amendment. And here we are on the House floor, and we're considering a bill that obviously we know has technical flaws. So the appropriate thing to do, if we can't fix this bill here on the floor, and our rules really aren't allowing us to do that. And I know we tried to refer this back to Rules Committee so that it could be fixed. Unfortunately, Representative Liebling, and I would rather not do this, but unfortunately I have to recommend that members would vote no on this bill. I don't think we can, with good conscience, ask members to vote in favor of a bill that we know has technical errors in the bill. And the bill really needs to be fixed before we move it forward. So I will recommend a no vote on the bill, and let's fix it properly. If you want to do it here on the floor, that's fine. We can take a technical amendment here on the floor, but somebody needs to write one that they think is correct, and I don't see one coming forward. So I'm going to ask members to vote no on this. We already tried to send it back to committee to fix it the right way. That was not accepted, so I don't think it's appropriate that we ask members to vote on bills that have technical problems with them. We know there's a problem. We know the references are wrong, and we certainly need to do our due diligence and not allow bills to move forward that are not correct. So I'm recommending a no vote.
The member from Olmsted, Representative Liebling.
Well, thank you, Madam Speaker. And Representative Dowd, if your members want to vote no on a bill that basically carries out something that your members directed the reviser to do when they were in the majority, that's fine. I mean, this is, first of all, I don't think you're correct that I was off the floor working with the reviser on this bill. So if there was a motion to send this bill back to committee, I don't think I was here for it. I missed that. I don't think it was on this bill. So there was no motion on this bill. And this is a unique bill because this is a reviser's bill. And reviser's bills, all our bills in fact, the large ones, have instructions to allow the reviser to make the kinds of technical corrections that we really can't make very well on the House floor. And that's the problem I ran into when I was talking with the reviser. She needs to spend more time with kind of a close, this is one that has a lot of moving parts technically. But our nonpartisan, very professional reviser staff is charged with doing exactly this. And so, if we can never in any bill let the reviser do the reviser's work of renumbering stuff, then I think we're going to just grind to a halt here in this body. So, members, I hope you're not going to make this little bill, which is really a bipartisan effort. If you notice, the co-authors on it are Abler and Cornish. I'm not sure whose bill it was to make this happen, but it wasn't me. It was somebody on the Republican side. And you want to make an example out of a bill that's really a Republican bill and that everybody just agrees is just a technical bill, and we can't trust the reviser to make any little technical correction. It just strikes me as silliness. So members, please vote green for the bill.
Representative Doubt.
Thank you, Madam Speaker, and I appreciate Representative Liebling making my case for me. This bill obviously does have technical errors. I don't think anybody's in disagreement to that, and I appreciate your comments that we shouldn't be making those technical corrections here on the House floor. I couldn't agree more. It was my error, and I apologize for that error. I thought this was the bill that we had a motion to re-refer to committee, and it was not. It was another one. That was my fault. So at this time, I will make a motion to refer this to the Rules Committee for some work in fixing these corrections, and we can bring this back when it's been corrected, and we can certainly pass it at that time. And I think Representative Liebling will certainly support this this motion as well.
Representative Doubt moves to refer the bill to which committee? Rules. Representative Doubt requests a roll call. Seeing 15 hands, there will be a roll call. Seeing no discussion to the motion, the clerk will take the roll. The clerk will close the roll. There being 55 ayes and 71 nays, the motion does not prevail. To the bill. Seeing no further discussion, the clerk will take the roll on the bill. The clerk will close the roll. Krisha votes no. There being 76 ayes and 50 nays, the bill is passed and its title agreed to. The next bill on the calendar for the day is House File 1113. The clerk will report the bill.
House File 1113 on the calendar for today, the second engrossment, an act relating to natural resources.
The member from Hennepin, Representative Wagenius.
Thank you, Madam Speaker. Members, these are the recommendations from the LCCMR on how to spend the Environmental and Natural Resources Trust Fund, in this case, the interest from the fund. The recommendation is for a little bit more than $38 million, 33 of it for fiscal year 14, and about a little more than $4 million for fiscal year 15. The funding levels come from a recommendation from the LCCMR on November 28th. I was not a member of the LCCMR at that time. I can tell you that the members here who were on the LCCMR and voted on that were Representatives Torkelson, Hackbarth, and Dill. So if there are technical questions, you know to where I am going to refer them. This bill has been through the Environment and Natural Resources Finance Committee and through Ways and Means. The dollar amounts did not change from the recommendations. The committees did add some language to further accountability. There are 46 projects here. That was out of 169 proposals. When you break down the money and look for next year, there will be $29 million in addition to spend. So let me tell you a little bit about where the money is being spent, the categories where it's being spent. And that would be, there's 6 categories, I believe. Natural resources, data, and information. That would be something like the biology that we've done for years. That's approximately $8 million, 21% of the money. Land, habitat, restoration, and recreation, almost $14 million at 35%. Water resources, almost $4 million at 10%. Aquatic terrestrial invasive species, about $11 million at 28%. Environmental education, less than $1 million, less than 2%. And administration and contract agreement reimbursement, a little over $1 million at 2.9%. If any member would like me to go over each of the recommendations, I would be glad to do so. But what I want to do right now is just highlight one of the recommendations, and that is the recommendation on page 14 of the bill, which is $4,350,000 in the first year and $4,350,000 in the second year, in support of an aquatic invasive species research center at the University of Minnesota. I have found that the most interest has been on funding that research project. And with that, members, there is an amendment.
The member from Washington, Representative Ward, for what purpose do you rise?
Point of personal privilege, Madam Chair.
State your point of personal privilege.
Thank you, Madam Speaker. I would like to welcome Nora Slawick, former representative. For those of you freshmen, she was here for 7 terms and has now gone on to greener pastures. But I would like you to welcome Nora Slawick, please.
There's an amendment at the desk. The clerk will report the amendment.
Wagenius moving to amend House File 1113, the second engrossment as follows. The amendment is coded A11.
Representative Wagenius.
Thank you, members. In previous years, recommendations have been made and people ask for extensions of time. And you will see in this amendment that there were 3 additional groups that asked for extension of time, and this is what the amendment does. It gives them that extension. And then at the bottom of the page, there's a little bit more accountability language so the public knows just how we're spending their dollars. I'd appreciate your support.
Seeing no discussion to the amendment, all those in favor of the amendment, please say aye. Those opposed, please say no. The motion prevails. The amendment is adopted. There are no further amendments at the desk. The clerk will give the bill its 3rd reading.
3rd reading, House File 1113, as amended.
3rd reading, as amended. Discussion. The member from Mille Lacs, Representative Erickson.
Thank you, Madam Speaker. Would the author yield to a question?
She will. Representative Erickson.
Thank you, Madam Speaker. Representative Wagenius, would you tell the body the dollars that are earmarked for research at the university or I think it's through the university, for zebra mussels, for invasive aquatic species. Is that in addition to the dollars that came out of the legacy funds previously? Is this a different department, or can you clarify that for me and maybe for others?
Representative Wagenius.
Thank you. Yes.
Did you vote no?
In the last session, we did appropriate some dollars to this just to get them started, but always the intention was that that was just a small amount to kind of barely get started. This now becomes the significant amount for the research center to actually hire some professors and get the graduate students and do the lab work that needs to be done to deal with both zebra mussels and carp and plants that are also invasive.
Representative Erickson.
Thank you, Madam Speaker. Would Representative Wagenius continue to yield?
She will yield. Representative Erickson.
Thank you, Madam Speaker. Representative Wagenius, is there any conclusive research that has been made available to us, for those of us, for example, who have invasive species in our lakes, like Lake Mille Lacs? Is there anything yet that they've concluded in that first round of research, or is this just building? I think maybe you answered that, but is there anything that we've learned yet?
Representative Wagenius.
Thank you. There has been previous research previous to this institute beginning on common carp, and we have learned a lot about common carp, or the state knows a lot more about common carp, and particularly knows about the vulnerabilities of those common carp, and you have to understand them and know how they're vulnerable in order to deal with them. And the problem is that the Asian carp and the common carp are very different kinds of carp. Even though they have that carp word in them, they're very different. So we are just at the beginning of understanding the vulnerabilities of the common carp, for example.
Representative Erickson. The member from Dakota, Representative Hansen.
Thank you, Madam Speaker. Would Representative Wagenius yield for a question?
She will. Representative Hansen.
Thank you, Madam Speaker. Representative Wagenius, I was looking on the spreadsheet and just wondering if maybe you could elaborate on the page 2 conservation program technical assistance with the Board of Water and Soil Resources. I see there's a $3 million appropriation there, and just wondering what that was.
Representative Wagenius.
Thank you, Madam Speaker. Representative Hansen, this is for staffing to help re-enroll folks who are coming off of conservation programs, to enroll them in new conservation programs, or to re-enroll.
Representative Hansen.
Thank you, Madam Speaker. If Representative Wagenius would continue to yield.
She will. Representative Hansen.
Thank you, Madam Speaker. And Representative Wagenius, so this is for on-the-ground personnel at the local level. So if landowners have, like the Conservation Reserve Program expiring, this would be for hiring staff at the local level who would work with landowners to re-enroll that or to put it into another conservation program.
Representative Wagenius.
Yes, basically yes.
Discussion. Seeing no further discussion, the clerk will take the roll on the bill. The clerk will close the roll. There being 113 ayes and 14 nays, the bill is passed as amended and its title agreed to. The next bill on the calendar for the day is House File 681. The clerk will report the bill.
House File 681, the Second Engrossment and Act relating to civil actions.
The member from Hennepin, Representative Simon.
Thank you, Madam Speaker and members. In 9 sessions in the legislature, I have never been more proud to carry a bill than I have been of this one. House File 681 is the Child Victims Act. It's long overdue, and the victims of child sex abuse in Minnesota really, really need your help today with this bill. Right now, as some of you may know, victims of childhood sex abuse are out of luck and out of time at age 24. At age 24, no matter when their abuse happened as a minor, and for almost any reason, and almost under any circumstance, they are out of luck and out of time, and the courthouse doors are shut in their face. That's wrong. And more to the point, it's not what this legislature intended over 20 years ago when it passed what was then a nation-leading breakthrough statute. So the problem here is that not only do individual perpetrators walk free, but so too is there a denial of responsibility for or from the institutions who, in many cases, aid, abet, and cover up this abuse. And that, maybe, is saddest of all. Many of you know that sex abuse, particularly against kids, is a crime of secrecy. Victims very often do not have the courage to speak out until many years later. And that's particularly true when the victim is a child. A child might lack the emotional skills or the maturity or the strength to come forward, especially when the perpetrator is somebody they trust or an authority figure, which is very often the case. And very often these are the same people who can use powerful forms of manipulation in order to lure the victim and the abused into the situation. And we've heard time and time again, in story after story after story, particularly in the last few years, where that's been true, unfortunately. And sometimes there have been many, many, many victims in serial fashion before an individual perpetrator or the institutions who aid and abet those perpetrators are uncovered and brought to justice. So it is oftentimes only later in life that the child victim will kind of connect the anguish of the present with the crimes and abuses of the past, and I've seen it. Over the last several years during my involvement with this issue, I have met with a number of child abuse victims, many of whom are in their 40s or 50s or even older. And if you could see what I have seen, if you could have been in my office during those visits, I think you'd have a very interesting, though painful, perspective on the scope of this problem and on the depth of this problem. It's a serious thing, and many of these people, by their own admission, would tell you that they are very, very damaged people in some respect. So, having met with those people and seen their suffering, I've also seen that they very often have no recourse, none whatsoever, because at age 24 the courthouse doors are shut in their face. And part of that suffering isn't just that the individual perpetrators walk free, but that there's no accountability for those who may have aided and abetted that abuse. And that's a problem. And we have the opportunity today to do something about that. A word about those institutions for a minute. I want to be very clear about this. I really believe that just as good people can do bad things, sometimes good institutions do bad things. And there are institutions that all of us like and enjoy or belong to, whether they're religious or civic or cultural or governmental. And just as we might have a parent or a spouse or a sibling or a child that does a bad thing, sometimes these institutions do bad things. Doesn't mean we don't still like them or love them or enjoy them or join them. But liking them, enjoying them, or liking them or loving them does not mean we don't hold them accountable. We do, and we must. I want to show you kind of why we're here today, why this bill, why now. And some of you have heard about this for a number of years, but I have a handout, some multicolored pages that you got here, and I usually don't like to bury people with paper on the House floor. I don't do it very often, but I think in this case it's warranted. If you look at the cover page, it's a yellow sheet, members. This kind of tells the story about why we're here. In 1989, this body Minnesota legislature passed this law. It's still in the books. If you go to either of the alcoves or go online and look at the statute books, this wording, this language is still there right now, to the comma. And you can read it for yourself. It basically says, in layman's terms, the statute of limitations in cases of child sex abuse ends 6 years after the person connected the dots, so to speak. That's how I put it. 6 years after the person knew or should have known of the connection between what happened to them and the injury that they're suffering. It's called delayed discovery. And Minnesota was not the first state, but we were one of the first states in 1989 to take this approach, and it was in light of a lot of new scholarly and medical and psychological evidence about how people process these things. We've come to learn more about it, by the way, in the terms of our veterans who come back from conflicts, PTSD and other things, and how these things are processed. So at the time, it was truly groundbreaking. But then along came a Supreme Court case a number of years later called the Blakowiak case. And for a lot of reasons that we could discuss on the floor, although we probably need not, although we certainly can, in the Blakowiak case, the Minnesota Supreme Court looked at that language, which we as a body passed in 1989, and said, that really means age 24. Now, I'm not going to go into why I think that was utterly wrongly decided, and why for many years advocates who were pushing for reform think it was a travesty and a real injustice, that the language we passed, you're reading it on the page, you don't have to be a lawyer or have any special skill or training, it means what I think it means and says what I think it says, why that language suddenly meant age 24, 6 years from the age of majority. But be that as it may, that is not at all what the Minnesota legislature or the governor at the time intended in 1989. And so this bill is the latest in a string of efforts over the years to fix that problem. And I think with this bill, finally, we've reached a solution that is workable, that is sustainable, that brings justice, and has some reasonable guardrails and compromises in place. So if you look elsewhere in this packet, the next few pages are some endorsements for the bill. You can read those on your own, including today's Star Tribune, which endorsed this version, by the way, not the Senate version. Expressly this morning in the Star Tribune endorsed this version of this bill. And I'm grateful for that, and the Rochester Post-Bulletin, and the Winona Daily News, and others. But members, and this is sensitive, and this is why I talk about the institutions that we may know and love and have affinity for, you look at the next page in your packet, and it's a very sensitive and unfortunate incident, or series of incidents that have come to light in the last few weeks about Shattuck St. Mary's School, a school that some of you may know people who went there, you may have great affinity for it. But if these allegations are to be believed, right here in our own backyard in Minnesota, we got a real problem. And it's not just with one or two or more individual perpetrators, it's with, if the allegations are to be believed, a culture of cover-up at that particular institution. And the sad fact is that all those people are out of luck because they're all over age 24. And the courthouse door is slammed in their face. They can't bring an action. They can't confront their abuser in court. They can't have justice. They can't have what so many people throughout Minnesota have in other walks of life. They can't have it because of the Blakowiak decision. And if you look at the following pages, which are, I guess, the orangish pages, and this is sensitive, but I want you to know that it's court action that brings documents like this to light. And there are what I would call some pretty smoking gun documents in here, if you look in your packet, members. And again, these things don't get revealed unless there's court action. Because in a court action like this, you've got to produce documents. And when you produce documents, this is what you find. And those documents will never come to light unless there's a court action. If you went to any of these institutions, it can be this one or anyone, and said, you know, just give us the documents and nothing else, they'd never do it. And that is what I fear is really driving this debate. So here's an example from Los Angeles, not Minnesota, Los Angeles. And if you look at the fourth paragraph down in the middle of the page, it's talking about an abuse situation. It says, the young boy involved is now about 18, so Kevin should certainly not return for another 2 years, by which the period for filing lawsuits will have passed. So members, if you don't think that people pay attention to the statute of limitations when it comes to shuffling people around or covering things up, this is an example. So some of you might say, well, that's California. We do things differently here in Minnesota. That's California. If you turn to the next page, here is, unfortunately, a homegrown example. And by the way, it's from the mid-'80s, and of course, all those people would be out of luck too. So this is from 1984, and this is a Minnesota case. And if you look at the second page, or the back of that sheet, here's a case where whoever wrote this memo says, it is my recommendation, given the seriousness of our exposure, meaning legal exposure, that the Archdiocese posture itself in such a way that any publicity will be minimized, and then there's a recommendation that this person be shuttled off to Albuquerque. The next page, I won't read to you, but you can see at the very bottom of there, that's also a Minnesota example, there's an explicit discussion of the fact at the bottom sentence, or second to last sentence, that the statute of limitation does not run out for another 2.5 years. The point of this is, institutions that we all may know and love and have affinity for, or donate to, or belong to, sometimes they do bad things, and in these particular cases, these claims would be time barred, but it shows that some folks really pay attention to this stuff. It really does matter. And that's unfortunately what's figuring in this debate. And so to the bill. As introduced, this bill was the product of a lot of thinking and a lot of work by a lot of people over the last several years. I carried a bill that had a different approach in 2007, which would have sort of returned us to this delayed discovery idea, but we came up against a lot of obstacles and confusion, frankly, in this body. And so there's a different approach this year in consultation with and in conjunction with and at the recommendation of former Minnesota Supreme Court Chief Justice Kathleen Blatz, a former member of this body, by the way, before she was on the bench, that a cleaner and clearer and more understandable approach would just be to say, instead of getting into this business about when you connected the dots and who proves it and whose testimony and you have to have an expert witness and all the rest, that the cleaner approach, and probably the fairer approach, is to go with what this bill does, which is, as introduced, not as here before you on the floor, as introduced, just lift the statute of limitations entirely for civil cases for childhood sex abuse. Just lift it. Just say, as we do for other things like wrongful death, that there is no statute of limitations. That was the bill as introduced. But along the way, in multiple committees, I met with stakeholders many, many times. Not only formal meetings in my office, but emails back and forth, conversations outside of the chamber, conversations in the hallway, met many, many times, including within the last few days, and made a number of painful and significant concessions, and I'll describe to you what those are. And by the way, I need to thank Representatives Lesch, Hillstrom, and others who guided me along the way as this went through their committees. They suggested some accommodations which, painful to me, I think make the bill better, more palatable, more reasonable. And it is about compromise. So, as introduced, no statute of limitation. As amended and as before you today, members, here's what the bill does. It only eliminates the statute of limitation as to future episodes of abuse. So presumably, if this would be enacted, August 1st of this year would be the effective date, and any abuse happening on or after that date, August 2nd, September 2nd, it would apply to that. So statute of limitations lifted. However, another guardrail in place, and I heard loudly and clearly from a lot of people that they wanted this, is to leave untouched the current standard for something called vicarious liability. Now, I know that's a mouthful. It's one of those jargon words, and we all, whatever our professions or pursuits or areas of expertise, cut down on jargon. But I want to explain what that is because I think it's important. Vicarious liability is basically a form of liability that is not fault-based. It's a fancy word for saying that, for example, I'll pick on a homegrown Minnesota company just for the example I've been using. Let's say a General Mills truck with the Cheerios logo on the side is driving on a delivery route and hits someone. Under vicarious liability, in most cases, with some exceptions, General Mills would probably be on the hook. Now, General Mills didn't order its driver to go off the road or hit grandma or do whatever, but because of the doctrine of vicarious liability, it's kind of what they're sounding about. They're vicariously liable through their driver. It's not fault. No one's saying General Mills is really at fault. That's vicarious liability. We change that. So going forward, we do not, or I should say we don't disturb the current limitation in the law on vicarious liability. In other words, they only have until age 24. And it gets even better when you look backwards. So the question becomes, what about going backwards? What about the memos I showed you here today on the House floor from the 80s or from the 90s or the Shattuck situation in the early 2000s? What happens then? What do you do about rear-view mirror stuff? How does that work? Well, what the bill says now is it will create a 3-year window. A 3-year window from presumably August 1st, 2013 to August 1st, 2016. And anyone who has an otherwise time-barred claim has 3 years to get their case in. If you bring it on August 2nd, 2016, you're out of luck. You had 3 years. You had your warning. You were told this is your window. If you don't get your act together, so to speak, and seek counsel and file some sort of claim, that's it. So it's limited. It's not forever liability. It's 3 years, and that's it. And we've done windows before. In this particular area of law, we did a window in 1989 and another one in 1991. And in other areas of law, like asbestos litigation and mesothelioma and other areas, we've done windows as well. So it's not a unique new concept in the law to create a window. So we create a window here, 3 years. So institutions came to us and said, look, if you don't have a window, when are we ever going to know that for the past cases, the rearview mirror stuff, when are we ever going to have a bookend on this thing? Well, the bookend is the 3-year window, and that's it. So we'll know by August 1st, 2016, if this is enacted, what the cases are, and then the window shuts, and that's it. And that seems to me a fair accommodation and a fair compromise that I made in order to address and accommodate some of the concerns. And then even in that window, there's a further limitation, again having to do with vicarious liability. You will only be able to introduce a cause of action or a claim against an institution if there is fault, not vicarious liability. So negligence, for example. And negligence is just a fancy word for the concept of failing to exercise reasonable care. That's all negligence means. It's nothing more mysterious than that. It's just a fancy word for you failed to exercise reasonable care. So, and that's a fault-based legal theory. So if General Mills, in my earlier example, I hate to pick on them, they didn't do anything wrong, but it's one we can all identify with. If General Mills, failed to repair an axle on the delivery vehicle and then it went off the rails or off the road, that's negligence, possibly. If at least someone could prove that it was, perhaps. We don't. It depends on the facts, but that's that kind of example. It's a fault-based legal theory. So rear view mirror, fault-based. Forward, not changing the current limitations on fault-based, and a window, a defined period of 3 years, August 1st this year to August 1st of 2016 to bring those time-barred claims. So the folks implicated in things like what I showed you before from the 80s, 90s, and 2000s would have their day in court, whereas they don't have their court right now. So I have to remind you, before we go on to the inevitable amendments, that some of these perpetrators of these crimes who go uncaught and unpunished, the evidence shows, will do this again and again and again. So when these people are not brought to justice and exposed, they will very often do the same thing to other kids. I recently came across an example of someone who admitted to doing that to 50 kids, boys. And that's got to stop. And it's cases like this that bring to light not only the documents of the kind that you saw, but also bring to light the perpetrators and, in some cases, some institutional abuse. But at the end of the day, the bottom line for me is, right now in Minnesota, the courthouse door is shut in the face of every victim of childhood sex abuse at age 24, and that's not right. And it's not what we intended as a body in 1989, and you have the possibility today to make it right through a bill that I think now, as amended, is balanced, it is nuanced, it is fair, and it really does something. It actually gives people that sense of justice and, in fact, does give them the justice and the ability to confront their abuser in court in a meaningful way. Thank you, members, and I ask for your support.
There's an amendment at the desk. The clerk will report the amendment.
Simon moving to amend House File 681. The second engrossment as follows. The amendment is coded E11.
Representative Simon.
Thank you, Madam Speaker and members. This is my amendment, and what this amendment does is respond to some of what I know you've been hearing from some local units of government, be they school boards or cities or others. And they're worried about their liability, and they're worried about insurance issues. And so what this amendment would do is to say that they are only liable for as much insurance coverage as they have. You'll see the word municipality. When I first saw that language, I thought, does that just mean cities? That's how I think of municipality. But if you look at the definition, it's pretty sweeping. It includes school boards, library boards, cities, towns, etc. So it's a pretty sweeping definition. And for those folks, it would say, for example, I'm just picking an example, let's say you only had $200,000 worth of coverage per incident, and there was a settlement or a jury verdict for $250,000, they'd only have to pay the $200,000. That's a hypothetical. That's what the bill does. This is yet another way, fourth or fifth way by my count, that I am trying to accommodate some of the concerns that some of the folks that you've undoubtedly heard from have, and that have maybe been calling you from your local jurisdictions. This, I think, is a common sense way to make sure that there's a reasonable limitation, but also to make sure that victims of childhood sex abuse get their day in court. I ask for your support.
Discussion to the amendment. Seeing notice. Oh, okay. Sorry. Representative Holberg.
Thank you, Madam Speaker, and I'd like to request a roll call vote on this amendment, please.
Representative Holberg requests a roll call. Seeing 15 hands, there will be a roll call. Representative Holberg.
Thank you, Madam Speaker, and will the author yield?
He will. Representative Holberg.
Thank you, Madam Speaker. Representative Simon, you didn't mention in your description of the bill an issue that I brought forth in a section of your bill that we discussed earlier, so I don't know when the right time is to have that discussion, but I definitely want to have the discussion on that portion of the bill, and I'll defer to your timing on that. But the amendment that's in front of us, I have a couple questions. Can you tell me, under current law and the liability caps for municipalities, school districts, etc., if they apply outside of this amendment?
Representative Simon.
Thank you, Madam Speaker. Representative Holberg, they would still apply. This does nothing to the tort claims limits. So, for example, members, if memory serves, for anything that happened before 2008, the current limit for these units of government is already $300,000, so that would not apply. And that's, you've given me an opening, Representative Holberg, to address some of the criticism from those local units of government. I mean, one of the things, and I've seen the handouts and the things that all of us have been lobbied on, what they omit, perhaps conveniently from their description, is that all units of government in Minnesota are already under the Tort Claims Act, which means you can never, ever get punitive damages against a unit of government. So no city or school district is ever going to get punitive damages. It's only actual damages, always. And they have damages caps. Remember, when we debated a few years ago, for those who were here, in 2000, I guess it would be 8, Representative Winkler had the bill for the 35W relief, and we debated that issue there about should we make a one-time exception to the Tort Claims Act in Minnesota. We did, for that very unique experience, but generally speaking, there are damages caps already. This just goes even further and says that not only do they have damages caps, but will go even lower if their insurance coverage is lower. So it's meant to accommodate them. My feeling is I'm doing it as a favor to others, but I'm interested in your reaction.
Representative Holberg.
Thank you, Madam Speaker and members. Well, first of all, they're already capped, so I don't know why they need this extra protection. We're going to have a situation where victims' right to recover will be in different categories depending on what type of institution the abuse occurred. But I guess what I'm really concerned about is if you actually look at the definition that this amendment references, it is a very broad definition of municipalities, and it actually includes family services and community-based collaboratives. And under that definition, entities that can be part of family services and community-based collaboratives are parents, churches, child cares, and so by including such a broad definition of municipalities, are we not also setting up two categories of churches, two categories of child care centers, two categories of parents, in that if you were part of a family service and community-based collaborative as part of the definition of municipality, you would then have this limit on liability that your neighboring church, child care center, etc. would not have, and I'd be interested in the author's reaction if that was his intent.
He will yield. Representative Simon.
Representative Holberg, Madam Speaker, and Representative Holberg, you're right. This absolutely does draw a line around certain institutions. As I said before, I brought this amendment in an effort to accommodate concerns of people who don't like this bill. So, I leave it to members here about what they think about that. But one of the arguments from the League of Cities and from the School Boards Association is taxpayers' money will be at risk because if there's a big judgment or settlement and insurance doesn't cover it, they'll have to go out sometimes for levy. There's a judgment levy and other things like that. This is to allay those concerns. Now, don't get me wrong. I thought those concerns were overblown and not well taken by me. I think, as you say, they've already got a lot of protections and even immunity from some of this stuff. This is an effort to address that argument on their behalf. I'm doing this as a favor. So I will tell you that if I had my druthers, I'd want the strongest bill possible. But I'm doing this as a favor, and yeah, it's a line, it's a choice. And this, though, would, I hope, put to rest at least the argument that they've been using, I take it with some effectiveness, that people's taxpayers are going to be on the hook if there's a big-time settlement somewhere for a school district and a city. I don't believe that's true because of the damages caps, but this is meant to cut that argument, frankly, off at the pass and meaningfully institute an even further cap. But as I say, I'm doing this to an accommodation as an accommodation for people who don't like my bill. So you can take that for what it's worth.
Well,
Representative Holberg.
I appreciate that answer, Representative Simon, and this is one of the issues of having amendments on the floor. We need to really kind of dig into them, and so I'll read in part some of the organizations that would be exempt if they were part of a family service and community-based collaborative. We have local health organizations, private and nonprofit service providers, child care providers, local foundations, community-based service groups, businesses, local transit authorities or other transportation providers, community action agencies, senior citizen volunteer organizations, parent organizations, parents, and churches that provide non-religious services. And so, members, in law, we have contemplated the exposure of local units of government to lawsuits by capping the damages. Why would we further set up a two-tiered recovery system for victims, and that all you have to do to minimize your risk is take out a very low insurance policy? Could it be as low as $2,000? Could it be as low as $200? And then that would limit your exposure. Now, some would say, well, we need to do this because we need to protect the taxpayer. Well, members, I don't know about you, but your local churches, I think their money's pretty hard to come by too. And the camps and the boys and girls clubs. All really great organizations that serve children that should have at least some level of protection too. Why are we setting up a two-tiered system? Municipalities, school districts, counties already have cap limits. This is a bad amendment. It would then set up, if you were a child care provider or a church in a family service organization, you would have a different exposure than if you're not. Members, the current protections for cities and school districts in state law give them protection for a wide range of activities. We should not be setting up a two-tiered system for recovery for childhood victims of sexual abuse, and I would appreciate a red vote on this amendment.
Further discussion to the amendment. Representative Doubt.
Thank you, Madam Speaker, and I'm not sure that I could say it much better than Representative Holberg, and I appreciate the author, Representative Simon's work on this bill. It is a sensitive issue and a sensitive subject. I, too, have the same concerns that Representative Holberg does in that this amendment will apparently create two different tiers of organizations with two different levels of protection for victims. And from a victim standpoint, I'm not sure they would see that their rights should be different based on what type of organization the person who was committing the act was part of. And frankly, because of that, I would very respectfully request members to vote no on this amendment.
Representative Simon.
Well, Madam Speaker, Representative Doubt, thanks for that. This is an odd situation. As I said, I'm just trying to accommodate critics of the bill who made the taxpayer argument, and this would be a further protection to them. I understand the two-tiered approach, and frankly, I'm very sympathetic to it. That wasn't the bill as I imagined it, of course, to have these two tiers, but I'm hearing so much from these other groups about taxpayer exposure that I thought I would address it through this amendment. So I'm going to vote for the amendment. I brought the amendment, but I certainly understand people's concerns.
Discussion. Clerk will take the roll on the amendment. The clerk will close the roll. There being 67 ayes and 58 nays, the motion prevails and the amendment is adopted. There's another amendment at the desk. The clerk will report the amendment.
Simon moving to amend House File 681, the second engrossment as follows. The amendment is coded A13.
Representative Simon.
Thank you, Madam Speaker and members. This is a clarifying amendment. I wish we didn't have to have it on the House floor, but after its last committee stop, a number of people said that the language should be more explicit. So this amendment does not make a millimeter's difference worth of substantive change in the bill, but it does explicitly say what I believe the bill already says, particularly in that last part, which says this paragraph does not apply to an action for vicarious liability, or the fancy Latin word for the same thing. So that's it. That's what I think the bill already does. Others weren't so sure, so I want to be absolutely explicit. This is a major guardrail and a major compromise in the bill, which is to say for that window period, that 3-year period, that you can bring those claims from beyond a few years ago, for that limited period, there is no vicarious liability against institutions. You have to show fault. You have to show something higher. You have to show something more. It's not enough just to say that someone was employed by someone. That isn't enough. You have to show fault. I think that's something that we can all agree on here. So this is just clarifying that because people wanted it said explicitly rather than implicitly in the bill right now. I ask for your support.
Discussion. Seeing no discussion, all those in favor of the amendment, please say aye. Those opposed, please say no. The motion prevails. The amendment is adopted. There's an amendment at the desk. The clerk will report the amendment.
Holberg moving to amend House File 681, the second engrossment as follows. The amendment is coded 0543.
The member from Dakota, Representative Holberg.
Thank you, Madam Speaker. I'd like to temporarily lay this amendment on the table.
Representative Holberg temporarily withdraws her motion. There's an amendment at the desk. The clerk will report the amendment.
Holberg moving to amend House File 681, the second engrossment as follows. The amendment is coded 548.
The member from Dakota, Representative Holberg.
Thank you, Madam Speaker. I'd like to temporarily lay this amendment on the table.
Representative Holberg temporarily withdraws her 548 amendment. There's an amendment at the desk. The clerk will report the amendment.
Holberg moving to amend House File 681, the second engrossment as follows. The amendment is coded 549.
Representative Holberg.
Thank you, Madam Speaker. I'd like to lay this amendment over as well.
Representative Holberg temporarily withdraws her amendment. There's an amendment at the desk. The clerk will report the amendment.
Liebling moving to amend House File 681, the second engrossment as follows. The amendment is coded A15.
The member from Olmsted, Representative Liebling.
Thank you, Madam Speaker and members. Members, this is really a very difficult and sensitive topic, and as Representative Simon has mentioned, there have been a lot of concerns raised over the path of this bill. And as I was listening to the discussion on the on that first Simon amendment, the discussion was about creating 2 tiers of recovery, or 2 tiers for the institutions. Well, members, I think the bill creates some tiers that are really unfortunate and unwarranted. And the bill, as it is before you, of course the main thing the bill does is to remove all statute of limitation if a victim is under 18 at the time. But what the bill also does is if the alleged victim is, or if the victim is 18 or older, they get 6 years, period. So it really creates a cliff, and it treats victims of sexual abuse very differently. I find this really troubling. I think we all agree that there is a problem. And the problem that Representative Simon explained is a very serious one. I think that we all on this House floor want victims of abuse to get the compensation that they need and deserve. And not one of us wants an abuser to get away. And certainly none of us wants an abuser to abuse again. But the way this bill is drafted, I do not believe meets those goals. I think that what we need to do is go back to the original language that Representative Simon handed it out and fix what the courts broke. Because the problem that we're in now is because of this decision that Representative Simon has alluded to. And I went back and read one of the recent decisions along these lines to try to understand what the court did. And what I found was what the court did was to say that the abuse is the injury. Now, I think we all know that that isn't really true. Of course, abuse is an injury. But there are other kinds of injuries that flow from that abuse for people and that they often don't know about until many years later. And therein lies the problem for many people. They may know they were abused as a child or as an adult, but they may not realize for many years that their PTSD or their depression or their inability to find a life partner is the result of that abuse. What the old statute does, the current statute, allows for that. It allows for a person who goes many years without realizing the problem, and then for some reason they suddenly realize what happened to them, not only that they were abused, but that they have some injury from that abuse. Under current law, the way the court has interpreted it, they're out of luck. If it's more than 6 years, they have no compensation. The door, as Representative Simon said, the door is barred. Well, Representative Simon's bill doesn't fix that. It fixes it for a child victim. If the person who's abused is 1 day before their 18th birthday, they can then sue forever, no matter why they waited. Say they wait 30 years. They never have to show why they sat on their rights for 30 years. But if they're an adult, their time is done at 6 years, no matter what the reason is for waiting. This is really unfair. It really creates two tiers. And in fact, the way the bill is drafted, it creates some very strange situations. Because you also have this language about an abuser who is no older than 16, who also, there's a different statute of limitations in that case. So what you get under the current bill is this. If the offender is 16 and the victim is 16, the limit is 8 years. Maximum 8 years. If the offender is 17 and the victim is 17, no limit at all. They can wait 30, 40 years before they sue. But if the offender is 17 and the victim is 18, you got a 6-year limit. So I don't think that's fair. I don't think it's fair to treat people differently based on what could be as little as 1 day of difference in when the abuse occurred. So I like the old law, except I don't like it the way the court interpreted it. I don't think it's right to say that there's a drop-dead 6-year limit from when the abuse occurred. I think we all know what I think the legislature knew when it drafted this language in 1989, that the offense itself, yes, that is an injury, but it's not the injury we're talking about. That people very often don't understand the harm that occurred to them until much later in life. And when they wake up and understand the connection, when they connect the dots, so to speak, that's when their time should begin to run. So what my amendment does is just that. Now, I have two forms of the amendment, and I believe the one we're on is the one that keeps Representative Simon's 3-year window. And I have to say I'm not entirely sure about that issue. In a way, I think it's kind of would be better to simply have the bill be retroactive so that anybody who fits the description of now, you know, anybody who was unfairly locked out before should be able to get in on the same basis of everybody else. But it's a bit of a compromise here in my amendment. It leaves in his 3-year window, but it changes the bill to just fix what the court broke. So this takes us back to what it says on his yellow sheet, only it makes it real. It says the injury and the abuse are not the same thing. So if you were abused and then suddenly 20 years later you suddenly connected the dots, say you were in therapy, say your marriage was falling apart and you went to therapy and suddenly the light bulb went on and you said, oh my gosh, the reason I'm having these difficulties with my spouse is because I was abused when I was a child. I knew about that abuse, but I never realized it was causing my current problem. That's when your time would begin to run. And I think that's much more fair. I think it accommodates the concerns of victims. I think it says to Minnesotans, we understand this is a really harmful thing in your life, and we're not going to lock you out just because 6 years have gone by. On the other hand, it's not going to let you sit on your rights for 30 or 40 or 50 years and come into court and never have to explain why you sat on your rights for all that time. And that's what Representative Simon's bill does. It creates those different classes of victims. To one class, it says you never have to explain anything about why you waited. I'm sure people have reasons why they wait, but they don't have to explain under his bill. They simply file and they say, I was under 18, and that's all the court needs to know about the statute of limitations. But if they were over 18, no matter what the reason was, pretty much, with some very limited exceptions, they don't get to file if it's been 6 years since the abuse. They just don't get to. No matter how good a reason, even if they didn't connect the dots, say they connect the dots in year 7, they're out. So that's why I brought this amendment, members. I have a lot of respect for Representative Simon, and I have a lot of respect for what he's trying to do, and I do know that we do have a problem right now under current law as the court has interpreted it. But I think that the way he solved the problem creates more unfairness and not less. And so that's why I would ask you to support my amendment.
Representative Simon.
Thank you, Madam Speaker, and Representative Liebling and members. I respectfully urge a no vote on the amendment. Although, Representative Liebling, I think what you're trying to do here is really a good thing. I get what you're trying to do. You are, in your own description, trying to return to something closer to what we thought we had in 1989. But I see a couple of problems with this particular amendment. Number one, I'm just not sure that the language gets there. I fear, in light of the Blakowiak decision, that you've got something in your bill which says, well, it kind of is an objective standard, yet it's kind of a subjective standard. I'm not sure the language would really overcome the doubts of the Supreme Court. And I just can't take the chance. I don't feel, on behalf of these victims, I can take the chance that we're going to be back here in another couple of years if this goes on the bill. I'm risk averse that way for something like this, knowing how the court has interpreted our language. The other, though, thing I would point out, two more things. First, in terms of this division that you're talking about, 41 states in this country have a division of a separate statute of limitation for childhood sex abuse. 41. So this isn't new. We're not particularly unique. And it's true. It's drawing a line. It's saying that if you're over 18, it's a different statute of limitations. This bill addresses folks who are minors. And that is something that sort of the law is accustomed to. It may be right, it may be wrong, but we're in the vast majority of states that do this. But I appreciate the distinction you're trying to make. It is a different tier, and there is a different statute of limitations, and I'm guessing the reason why is that there's a qualitative difference, that sexual abuse against a child is different. It is, frankly, worse in many instances because of the trust of figures of authority who often prey on these people, and there's something more insidious about it that we as a society have decided needs to be treated differently and in a special category. So we joined 40 other states in doing that. One other thing, though, as I was puzzling over this amendment since I saw it yesterday, Representative Liebling, has to do with this idea of repressed memory. One of the critiques of the 1989 legislative approach was that somehow this would open the door to repressed memory and sort of junk science about repressed memory or recovered memories. Now, the good news on that front, for those who have concerns about that, is the Minnesota Supreme Court pretty much took care of that one once and for all last summer. Last summer, right. Summer of 2012, in a case called John Doe 76C. That was the name of the plaintiff, John Doe 76C. The Supreme Court of Minnesota pretty much shut the door once and for all and forever on repressed memory when it said that repressed memory kinds of theories are not scientifically supported and in fact can't even be admitted into evidence. It's not just that they ought to be entitled to less weight or qualified somehow or explained or disclaimers. It's that the jury can't even see it. It can't even be introduced into evidence. So I think for those of you who now or formerly had concerns that someone's suddenly going to watch a documentary or see something on TV and somehow get it in their head that this happened to them, in terms of proving that in court, the Minnesota Supreme Court's pretty much shut the door on that. You can look up the case, John Doe 76C, I think July of 2012. The reason I bring that up, Representative Liebling, is I worry after the Blakowiak case that if we pass this amendment, it may be unintentionally, of course, setting up a trap for the unwary. Because if this goes back to the connect the dots situation, it could open up arguments that in order to connect the dots, some people are going to have to use some form of repressed memory theory, which we now know the Supreme Court doesn't allow. So I'd hate to see victims be in the situation where they do in fact connect the dots later in life, as the vast majority do, and then their case gets tossed, or effectively tossed, because a court says, look, I read John Doe 76C, and the only way they can connect the dots is by doing this manufactured memory or repressed memory. Therefore, they can't introduce any of that, and then the case might go away. So I have a lot of questions and concerns about this. I'm not saying that your overall approach isn't a good one, frankly. I mean, ideally, we would go to something very close to our original 1989 intent as a body here in the Minnesota legislature. I'm just not convinced that this particular language and this particular drafting would get us there. So for that reason, not because your overall idea is somehow flawed, but for that reason, I think I respectfully urge a no vote.
Representative Liebling.
Well, thanks, Madam Speaker, and Representative Simon. Well, Representative Simon, I have the same problems with your bill that you mentioned having with my amendment. I'm risk averse too, and I worry about what your amendment is going to do to victims and to our legal system. And the fact that 41 states, I didn't know that, but even if 41 states have a different standard for children and adult victims, the difference between 6 years and no limitation is a pretty big cliff, a very big cliff. And sure, kids and adults are different, but you could have somebody who's 18. We all know an 18-year-old who's immature. We know that sexual abuse has enormous impacts. We know if we're talking about people who are in trusting relationships with each other, being 18 is no guarantee that you're ready to report it or that you feel strong enough to go to the police or anything like that. And 18-year-olds can be of all kinds. You can have an 18-year-old who's low IQ, who's emotionally distressed. That person doesn't get any special dispensation in this bill. They're treated like an adult. An adult is an adult is an adult. And a person who's a day before their 18th birthday is a child. And that's the bright line that's drawn in this bill. And I just think that there's a lot to worry about in this bill, and I agree that I'd rather not be bringing an amendment, and I'd rather not be doing this as an amendment, but I'm a lot less worried about the amendment than I am about the bill, members, and everybody will decide how they want to vote on my amendment, but if my amendment doesn't go on or something like it, I certainly can't support the bill. Thank you.
Discussion. Seeing no further discussion to the amendment, all those in favor of the amendment, please say aye. Those opposed, please say no. No. The motion does not prevail. The amendment is not adopted. There's an amendment at the desk. The clerk will report the amendment.
Liebling moving to amend House File 681, the second engrossment as follows. The amendment is coded A16.
Representative Liebling.
Thank you, Madam Speaker. Well, members, this is just the same thing without the 3-year window, so, Madam Speaker, I'm going to withdraw the amendment.
Representative Liebling withdraws the amendment. There's an amendment at the desk. The clerk will report the amendment.
Allen moving to amend House File 681, the second engrossment as follows. The amendment is coded A17.
The member from Hennepin, Representative Allen.
Thank you, Madam Speaker. I want to thank Representative Simon for his patience for those of us who have not been working on this bill for years, and for walking a lot of us through this bill. I had a number of concerns about it, and at this point I am supporting the bill. I'm more concerned about what it doesn't do, and I'm not sure I still understand why it doesn't fix the Supreme Court case. And at first I thought it was going to have some unintended consequences because we are removing the, in subdivision 2, we're removing, for adults, we're removing the tolling. Representative Simon's bill, it removes the new or had reason to know, but we know that the Supreme Court interprets that not as this legislature intended. So basically there is no tolling, and the injury is equated with the sex abuse, and so that the knowledge, there isn't any tolling. And if you think about sex abuse, it shouldn't be for civil and damages. It's about the injury and about compensating someone for the injury, and so it shouldn't be about when the act occurred. For civil purposes, it should be about when the injury manifests itself, and oftentimes that is beyond the 6 years. And oftentimes, even when you know you have an injury, you oftentimes, sexual abuse victims oftentimes don't even connect it with the sexual abuse, and it may take another 5 years for them to make that, so that they can prove that it was caused by the sexual abuse. And I don't think, I think the facts were horrible in this case, and I think that's why the court ruled that way. But it's something within our power to change. And that's what I believe for children that Representative Simon's bill does that. And Representative Lee raises some good policy points, and that yes, this is something new. We don't really know how this is going to play out, and there may be some unintended consequences. But I think something had to be done, and I think this. I think this is a good bill. I think, and as far as, but I think an ideal bill would have been, let's have a window, and then let's have a discovery rule, a liberal discovery rule. But if that is something that is somewhat untested, so I can see we're airing, something that just is very protective of victims, of children who have been abused. But the thing is that what it doesn't fix here is with adults. So that means if somebody sex abuse there's 5 degrees. It is varying degrees of criminal sexual conduct, and it's not just about sexual abuse against children. It's about sexual assault against women. It's about varying degrees of use of a weapon, and so really it's something that really needs to be fixed. And so I'm not sure why that could not be fixed here. And so basically by deleting the no or had reason to know, we should have fixed that. And by deleting it at this point, it really doesn't matter, because that's what the Supreme Court interpreted. And I just think it's odd that we would concede to something that we disagree with and then codify it. And so I hope that at some point that this can be fixed. Thank you. I withdraw my amendment, Madam Speaker.
Representative Allen withdraws her amendment. Representative Holberg, would you like to return to your amendments?
Well, Madam Speaker, I had talked with the bill author about an issue with the bill earlier, and he didn't even address it in his opening remarks, and I would prefer to have that discussion first.
Discussion to the bill. Representative Simon.
Yes, and Representative Holberg, I'm happy to do that now. I omitted it from my opening remarks. Another change that I made along the way in a committee, this time in the House Judiciary Committee, in response to the concerns of a number of members on that committee, was to make sure that we're really focused only on adult misconduct here, not necessarily by misconduct by minors against minors. And so, as a concession, and it was a concession on my part, not what I would have originally wanted, I'll tell you that right now, but as a concession in order to get the bill passed, I accepted an amendment that would say that the bill does not change the law in the case of a perpetrator who is under the age of 16. So if a 15-year-old, or 16-year-old for that matter, or a 15-year-old abused an 11-year-old, the law is unchanged. We're not doing these new things for those people. And the theory, and if the people who, this isn't my argument, but the people who push for this, and I'm not going to out them, but if they wish to speak on the floor, they can, but I'm not going to name them. Their argument, as I understood it, was, look, we treat juveniles differently in our society anyway. And should a kid, so the argument goes, not my argument, but their argument was, should a kid be subject to liability in the future for something he or she did that was dumb, and even more than dumb, harmful, really, really, harmful to someone at age 14, should they be subject to something they did as a juvenile, should they be subject to liability when they're 34, 35, 45? That was the argument. Again, I'm just translating what others told me were their concerns, and that's why I agreed as a matter of getting the bill forward to put that amendment on. So that's the issue we discussed, just for the record.
Representative Holberg.
Thank you, Madam Speaker and members. This is a pretty important issue, and where now campaigns have basically fallen to the level of hand-to-hand combat. And hit pieces go out on individuals that say that they are soft on sex offenders because they voted against a bonding bill that had money for an expansion at the St. Peter Hospital. And we all know the fact that words matter. I've said this on the floor for years. I need all of you to pay attention because we have a Sophie's choice in this bill. I approached the bill author and Representative Hillstrom this morning and asked them to please progress this bill because of this language that Representative Simon just addressed. And basically what it says in this bill is that if the perpetrator is 16 and no matter how little the victim is, the victim has to age 24. So a 17-year-old can abuse a 3-year-old, unlimited statute of limitations. A 16-year-old abuses a 3-year-old. When that 3-year-old turns 24, it's done. And so we have a very politically sensitive bill in front of us. And if you want to vote for an extension for the statute of limitations, you're going to be voting for this problem that's also in this bill. And so I'm going to make a motion, and I'm sorry we had motions earlier today to send things back to rule, but the members of this body should not be asked to vote for a bill with a flaw in it like that, because we can't change it on the floor. And so you are faced today with a choice. If we don't send this back and you vote no on the bill, you know what the lit piece is going to say? You don't care about victims because you voted against extending the statute of limitations and fixing this problem. You vote no on the bill because you're uncomfortable with the fact is if a 16-year-old abuses a 3-year-old, that 3-year-old has different rights than if a 17-year-old abuses them. There's going to be another lit piece against you. And we should not be put in a position of having to make that choice on a vote on this bill. This is not a partisan issue. There are people on both sides of the aisle, on both sides of the issue. This is a spectrum issue. It's not right or it's not wrong how you feel about the issue, but it is wrong that we be put in a position where we have to cast, we don't get maybe or half or I like part of it or most of it. We get a red and we get a green. And this issue about a different standard just because the perpetrator is 16 was not fully vetted. I talked to members on the Judiciary Committee. Nobody, to their knowledge, ever raised the issue
of the disparity of age between the perpetrator and the victim. I mean, I'm telling you, I'm familiar with the situation with a 16-year-old man, a young man abusing a 9-year-old girl. And the thought that because that person was only 16, that 9-year-old would have limited recourse because of a problem in this bill is wrong. So with that, I move to send this bill back to rules and ask for a roll call vote.
Representative Holberg moves a re-referral and requests a roll call. Seeing 15 hands, there will be a roll call. Representative Simon.
Thank you, Madam Speaker and members. Representative Holberg, I understand your frustration, and you and I had a conversation before this bill. It's not an amendment I would have preferred to offer. I think the people who wanted it know that it's not one I would have preferred to offer, and I would personally like it not to be in this bill. But let me tell you what I will guarantee you. This bill, if I'm fortunate enough to pass it today, will go to a conference committee. There's no question about that. And I promise you here today to revisit and address that issue. You know my preference. My preference is I like the bill as introduced before this amendment. Otherwise, I would have put a restriction in the original bill. So I'm with you in spirit, but I don't see the need to stop its progress. So I will pledge to you, I will promise to you to revisit this issue. And frankly, you know the legislative process. There are bottlenecks. And sometimes members, as a condition of their support, ask for certain things, or at least an implied condition. And so that was done in this case. You know where my sympathies lie. I don't think, personally, if I could choose, I wouldn't make the distinction that is in the bill as amended, but you know as well as I do in the legislative process, sometimes to get a bill passed, you have to make accommodations, and I've made many, many accommodations. This is also an illustration on this bill, maybe a sign that we've gotten it mostly right, that some people think it's too harsh and some people think it's not strict enough. And this falls into the latter camp. And so, Representative Holberg, I don't know if I can convince you to withdraw your motion, but at least I want to convince members that if there is a motion and when I vote against it, I plan to and will revisit this issue, and I will talk to the members whose concern this addressed. I'm not going to name them. And I will see whether, if this comes back from conference without this provision in it, they will still support the bill. I mean, I'll be utterly candid, Representative Holberg. I have to count votes, and that's what I had to do in the committee process. But I'm with you in spirit, but I would like to go ahead and hopefully pass the bill, and then we can and I will revisit this issue in conference.
Representative Holberg.
Well, Madam Speaker and Representative Simon, I don't doubt your intent, or you have always been really good, but I just think that the choice in this bill is unfair. This is a recorded vote. This is a yes or no vote. And it's not fair to put the members of this body on either side of the aisle in a position to vote for a bill that has some really good things in it, but leaves a situation where you have young victims that have less rights. It's just wrong. There are problems, and quite frankly, it's probably a problem that shouldn't be worked out with 6 people in the legislature. It should be probably something that comes back to the floor of this body to decide, how are we going to handle this? Are we going to base it on the age of the victim? Are we going to base it on the disparity between ages? If a 16-year-old victimizes a 14-year-old, is that okay to have a shorter statute of limitations? Those are some pretty big, weighty issues that have to be resolved around this issue, and I really think that this should go back to the Rules Committee, allow people to have discussion, bring an amendment to the floor to fix it, allow this body to have that discussion, and not force members to choose between a green vote on the bill because they want to extend the statute of limitations, but support less protections for preschoolers just because the perpetrator was 16 years old. It's wrong.
Representative Simon.
Well, Madam Speaker and Representative Holberg and members, as I said to you, I understand your frustration. I share the frustration. But unlike other motions to re-refer, which have to do with some procedural abnormality or some skirting of the rules, how can I say this? I want to say this as diplomatically as possible. everyone had an opportunity in the committee to talk about this. The amendment was offered. There was an opportunity there. It was adopted. Everyone had an opportunity on this floor today to offer an amendment to that effect, to take it out of the bill. I guess that's all I can say without going too far for my own good. I don't think this is the proper reason to re-refer a bill. You have my pledge. It's a promise. It's a certainty. I will revisit this issue, and I will go even further. I will try to get it removed from the bill. If I can. That was my original preference, but I don't think that's any reason to stop the bill. Laying this bill over or sending it to a committee will invite, frankly, further mischief. And there are people outside of this room right now who would love to lay the bill over so they can draft 5, 10, 12, 15 more amendments that they didn't think about that could be very troublesome. And I just can't have that because it's going to invite some outcomes and some possibilities that I think could really gut the bill. So I respectfully urge a no vote.
Seeing no further discussion on the motion to re-refer, the clerk will take the roll on the motion to re-refer. The clerk will close the roll. There being 54 ayes and 70 nays, the motion does not prevail. Representative Holberg, did you want to return to any of your amendments?
No, thank you, Madam Speaker.
Representative Holberg withdraws her amendments. There being no further amendments at the desk, the clerk will give the bill its third reading.
Third reading, House File 681 as amended.
Third reading as amended. Discussion. Representative Holberg.
Thank you, Madam Speaker. Will the bill author yield?
He will. Representative Holberg.
Thank you, Madam Speaker. And Representative Simon, how does the issue of tolling work? So is it that any child that turns 18 after the enactment date would have unlimited statute of limitations for anything that happened to them as a child? Is that correct? That is, unless their perpetrator was 16 or 17 years old.
Representative Simon.
Madam Speaker, Representative Holberg, and members. Well, I thought you were going in a different direction with your question, and that the buzzword is tolling. Tolling is basically the concept of a pause on the stopwatch of the statute of limitation. So, for example, the law school example you always hear about is someone's in a coma, and for whatever infraction, there's a let's take it out of this bill. There's some crime, or there's some, I should say, civil cause of action, and there's a 4-year statute of limitation, and at 3.5 years, the person's in a coma for a year. That's a great example, the classic example of where you toll or delay the statute of limitation. You know that, but I'm just saying that for the record. So, apart from that, I'll try to answer your question directly. Your question was, is it the case that a person who allegedly suffered abuse before the age of 18 could then sue going forward without the current limitation of age 24? The answer to that is yes, if I understood your question correctly.
Representative Holberg.
And Madam Speaker and Representative Simon, so what age or pocket do we lose that may not be, if somebody doesn't take advantage of the 3-year window, if they're under the age of 18, that will not be a problem because on the enactment date, at any act in the last 18 years basically will be told in under the unlimited statute of limitations, except for the 16 or 17-year-old perpetrator issue. Is that correct?
Representative Simon.
Thank you, Madam Speaker and Representative Holberg. If I understand your question, that is correct. I'm not sure what you mean by who do we lose, though, and that's the part that I didn't quite understand. I thought that's what I heard you ask, who do we lose or who falls away or something like that. You might want to clarify that.
Representative Holberg.
Well, thank you, Madam Speaker and Representative Simon. I'm just trying to get a really clear picture of the interaction between current law and standards, the window, and the new standards, and where there are any hard, bright lines. So those that would lose their ability would be those people that are older than age 24 that fail to use the window in the 3-year period. Is that correct?
Representative Simon.
Madam Speaker, Representative Holberg, that is correct.
Representative Holberg.
All right. Thank you, Madam Speaker.
Further discussion. Representative Doubt.
Thank you, Madam Speaker and members. Unfortunately, we're in a position that I think, I kind of wish we weren't in. A vote for this bill, frankly, is a bad vote. And unfortunately, a vote against this bill, I think, might be a worse vote. And we made an attempt to send this bill back to committee to very sincerely take some of these things in a different format, in a different discussion, and try to fix them before making members take a potentially bad vote here on the House floor. And I very much respect Representative Simon. He and I have worked together on numerous issues in the past and have a great working relationship. And Representative Simon, I think what we may have done is missed an opportunity to really work together and come up with a solution that might really ultimately mean better policy. And I understand the realities of the politics of this place and having to get enough votes to maneuver a bill through this process. And unfortunately, and I'm going to very respectfully disagree with you, but I think we might be putting the politics of this, or the ability to try to move this bill through ahead of the policy of the bill. And I think we've really missed an opportunity to fix this bill in the committee process. And I know we've said numerous times that that's what we want to do. And this is a sensitive issue, and it's a very sensitive subject. And obviously we've had an emotionally charged debate here on the floor about this issue, and the ramifications for victims of these sorts of incidents are certainly very personal and very sensitive issues. So I think all of us appreciate that. I'm going to vote for the bill today. Frankly, I wish I didn't have to do either, because I think the bill does need some more work, and I think that we have missed an opportunity, and I say that with all due respect, Representative Simon, to really move the bill back to committee and fix some of the things that I think could be fixed in the bill to make it a better bill and better policy. I do appreciate and want to say that I appreciate your efforts in tackling an issue that, of course, we all know is a sensitive issue. So I'm going to vote for the bill, but I understand that every member is going to have to decide which way is worse. And unfortunately, I wish we could vote for something that we all think is a great policy instead of having to make a decision of the lesser of two evils. But I appreciate that. Thank you.
The member from Crow Wing, Representative Ward.
Thank you, Madam Speaker. And members, I rise to ask you for a green vote as well. And Representative Holberg, you are a respected and admired colleague in this body, like you are, Representative Simon. And when the two of you were debating and talking about this bill, I was listening clearly, and you both have great points. And I know that, Representative Simon, that you were listening and you will do what you said you will do. And Representative Holberg, I really appreciate and respect the knowledge that you have on all of these kind of personal issues and the wealth of information you bring to this body with that. And I'm with you on that, and I will hold my colleague over here to his feet to the fire as well. Members, I just want to share with you, I'm a co-author on the bill, and I didn't know a lot about the bill until I got an email from one of my constituents. And I just want to I want to share with you that email from the constituent. And this is Representative Dowd, a difficult issue and situation. And just let me share this, members, if I might, please. Representative Ward, I am a survivor. I encourage you to promote and pass the new bill, the new sexual abuse bill. I'm a survivor of childhood sexual abuse. I was abused from the age of 12 until 17. All this started in 1948. 1948. I did not seek help until 1993. 1993. I did not realize how it impacted me. I struggle yet today. Fortunately, I was able to have a productive life, marriage, and raise 4 successful boys. And I cannot begin to tell you in this note what I went through during the abuse and the therapy that began in 1993 and continued until 1999, much of it weekly, as I was overwhelmed with what had happened. I will be glad to meet with you and share more details. And then she said a few more things, and I had the pleasure of meeting this person and sharing some more with her. And then also, members, after I got this email, one of my own very close members of my family also shared with me some tragic news that what they went through too. And so, members, while this bill needs some work, Representative Holberg, as you indicated, and Representative Simon, and you agreed to, I would really ask and encourage you to move forward on this bill because delays are only going to cost the victims, members. Delays are only going to cost the victims. So I'm asking for a green vote on Representative Simon's bill. Thank you.
Discussion. Representative Simon.
Thank you, Madam Speaker and members, and thank you very much, everyone, for an informative, truly informative debate. I have to say that sometime or another we've all probably wondered whether floor debates really make a difference. Doesn't everyone just come in here and basically have their mind made up? Does anything that's said on the floor really change someone from red to green or green to red? Or does it change someone's thinking on an issue? I have to tell you, this floor debate really kind of to me, convinces me that the floor debates can matter. I will be candid, I did not know before today that Representative Holberg, and perhaps others, I assume she's thinking of others, had the concern with the one portion in the bill. But I will tell you that I will do my very best to fix that, and I hope that existence of that portion in the bill, the differential between the perpetrator who's an adult and the perpetrator who's a minor, I hope that doesn't persuade you to vote against the bill. I hope you don't fall into the trap of the perfect being the enemy of the good here. So I hope we can move this on to conference committee. That provision, which Representative Holberg talked about, is not in the Senate bill. We will hopefully go to conference committee, and at that point we will revisit this issue. I will consult quietly with those who brought this issue to my attention to see if maybe as a result of this floor debate they no longer think that's as good an idea as they once did, and you have my pledge on that. But members, looking at the big picture here, one thing that I didn't purposely announce at the beginning of this debate, but I will now, is that from time to time during this debate, in the gallery and certainly outside of this room, but here in the Capitol today, are victims of childhood sex abuse who are adults now. They're in their 30s, they're in their 40s, they're in their 50s, and in one case that I know about that's here today, in their 60s. And these are people who suffered and endured some real lasting damage. And as you know, the courthouse doors are slammed in their face if they're over the age of 24. This legislature in 1989 was a groundbreaker, a pathbreaker, in moving to a new way of looking at these cases. And a Supreme Court case, unfortunately, finds us here, trying to correct course and get back to a place where the victims, where the survivors, really can get justice and really can have their day in court. As people from both sides of the aisle have said on many other issues, sometimes Democrats, sometimes Republicans, depending on the issue, let's think about the kids, not the grown-ups. Let's think about the victims, and let's not think so much about the particular concerns of the adults in this situation. These kids, later adults, deserve the justice that this bill would give, It's a series of accommodations, of compromises, and I think that it's almost there in terms of achieving that right balance. And so for the sake of those folks who are here today, and for the people all over Minnesota who have endured these horrific instances of abuse, give them that day in court, and please vote yes on this bill, the Child Victims Act. Thanks very much.
The clerk will take the roll. The clerk will close the roll. There being 115 ayes and 7 nays, the bill is passed as amended and its title agreed to. Reports from the Committee on Rules and Legislative Administration.
Report from the Committee on Rules and Legislative Administration. Murphy E. for the Committee on Rules, pursuant to Rule 121 and 3.33, designates the following bills to be placed on the calendar for Thursday, May 2nd, 2013. House File Numbers 1390, 195, Senate File 1270, House File 590 and 1284, and Senate File Numbers 510, 825, and 843. Murphy E. for the Committee on Rules and Legislative Administration, pursuant to Rules 121 and 333, designate the following bills to place on the calendar for Friday, May 3rd, 2013. House Files 92, Senate File 489, House File Numbers 902, 634, 694, 1117, 1136, and Senate File 380.
Motions and resolutions. Okay. There are copies of the non-controversial motions at the House desk and online. If there are no objection, we will take action on these motions first. Hearing no objection, these motions prevail.
Anderson P., Gunther, Hamilton, and Poppy introducing House Resolution Number 6, a House resolution recognizing Minnesota State Grassland Month. The resolution has been referred to the Committee on Rules and Legislative Administration. Keel moves that House File 92, now on the calendar for the day for Friday, May 3rd, 2013, be re-referred to the Committee on Agricultural Policy.
The member from Polk, Representative Keel.
Thank you, Madam Speaker. I would request a roll call on this motion. I would like to see that House File 92 be re-referred to Agriculture Policy, as we have not had a chance to discuss this issue with the change in the hours from 40 to 48. Thank you.
Representative Keel requests a roll call. Seeing 15 hands, there will be a roll call. Representative Winkler.
Thank you, Madam Speaker. Members, I would ask members to vote no on the Keel motion. I understand that there is objection, concern, opposition to requiring employers of agricultural workers to pay overtime after 40 hours instead of 48. But rather than re-referring it to committee, I might suggest you check the amendment postings to House File 92, which already includes an amendment from Representative Poppy to remove that section of the bill. So if all goes according to Representative Poppy's plan, that may or may not even be in the bill when it's heard on Friday. So I would ask members to vote no, and this will be addressed when the bill is taken up on the floor.
The member from Representative Keel. Oh, I'm sorry. I didn't see. Representative Hamilton.
Thank you, Madam Speaker. Will Chair Poppy yield for a question, please?
She will. Representative Hamilton.
Chair Poppy, I believe you understand what the issues or the concerns are, and the reason why we do need the 48 hours. The question is, could you tell us a little bit about your amendment and what type of support do you think you have for your amendment on the floor?
The member from Mauer, Representative Poppy.
Thank you, Madam Speaker, and Representative Hamilton. I do have an amendment, and it would be to delete the section that talks about changing it from 48 to 40, and it is more specific on agriculture. So it will be the 48-hour threshold. So at 49 hours, that's when the overtime would begin to be paid. And the people that I've talked to on this side of the aisle that I know to be friendly to that are supportive of it. And Representative Winkler has assured me that he will not openly oppose it. I think he will be perhaps amenable to it.
The member from Cottonwood, Representative Hamilton.
Thank you, Madam Speaker. Thank you, Chair Poppy. And, dealing in agriculture directly, specifically livestock production, it's a 7-day-a-week job. And so that's where we're always looking for that 48 hours. I've directly worked in this my entire adult life, and I know and understand it and choose this as a profession. So thank you, Representative Poppy, for that.
Seeing no further discussion, Representative Poppy.
Thank you, Madam Speaker, and I'm just asking perhaps not to have the re-referral, if we can just take it out of the bill rather than actually having it go back to the Ag Policy Committee to discuss. I guess I'd prefer just to actually remove it from the bill, and I'm hoping for a lot of support when this amendment comes up on Friday. Thank you.
Representative Keel.
Thank you, Madam Speaker. Being that everyone is amenable to working on this issue, I will remove the request for a roll call and the re-referral.
Representative Keel withdraws her motion. Announcements. Representative Poppy.
Thank you, Madam Speaker, and I'll just once again announce that we will have the I-90 gathering. The I-90 Coalition, which is loosely now the gathering of the people who represent in the House and Senate and the Republicans and Democrats along the I-90 corridor. But what we do once a year is have a great event with wonderful food and other items, beverages as well, from our districts, from southern Minnesota. And we do invite people to come to that gathering. I believe it begins at 5:30 at Kellogg Square Apartments. If you have any questions about that, I think on the Republican side, Representative Hamilton and others would be able to talk about it. If you have questions on my side of the aisle, you can ask me about it. But it is a very good meal for $5, and it's a great way to usually celebrate spring. So we invite everybody to come to, and I know that Representative Gunther is busy preparing for that as we speak. So I encourage people to attend. Thank you.
The member from Dakota, Representative Garofalo.
Thank you, Madam Speaker. And just to be clear, because this problem happened a couple of years ago, for any of the viewing public, this is not an open invitation to the state of Minnesota to attend. I believe this is a members-only event. Just wanted to clarify that, because 2 years ago I got an email from someone who actually thought they were invited. So just to be clear, sorry.
Representative Poppy.
Thank you, Madam Speaker, and Representative Garofalo. It is an event that is for the legislators to really have some social time together, to get to know each other, to be able to have a little bit less contentious of a situation, and I appreciate that clarification.
Announcements. The member from Beltrami, Representative Purcell.
Thank you, Madam Speaker, and members, if you'd listen up for just a minute, please. Life happens to us every day, and some days are a little more special than others. At least we hope so. Last Monday, April 29th, one of our colleagues was recognized for his life's work, and so I just wanted to pay a little respects to my friend, and I think all of our friend and colleague. And this individual, John Ward, he's got a lot of things going for him, and he was Minnesota Teacher of the Year in 2006. He's been a coach, softball, girls softball, and floor hockey. Taught school 34 years, Brainerd Teacher of the Year back in 1992. Well, anyway, last Monday, he was put into the Brainerd Warriors Coaching Hall of Fame. And that's something that doesn't happen every day, and I just thought you'd join me and give him a round of applause.
The member from Olmsted, Representative Liebling.
Thank you, Madam Speaker. And since Representative Huntley isn't here to announce it, I thought I'd just remind members that the Health and Human Services Conference Committee is meeting at 8 o'clock tomorrow morning.
Representative Carlson.
Members, this is for the Ways and Means Committee members. We will be meeting tomorrow morning at 8 a.m. and we'll be taking up the energy bill, and we'll also have the bill dealing with the unionization of child care workers. So with the predicted snowstorm, folks can leave early so we can get started right at 8. Thank you.
Announcements. Representative Murphy.
Thank you, Madam Speaker. I move that when the House adjourns today, it adjourns until 10 a.m. Thursday, May 2nd, 2013.
Representative Murphy moves that when the House adjourns today, it adjourn until 10 a.m. Thursday, May 2nd, 2013. All those in favor, please say aye. Those opposed, please say no. The motion prevails. Representative Murphy.
I move that the House do now adjourn.
Representative Murphy moves that the House do now adjourn. All those in favor, please say aye. All those opposed, please say no. The motion prevails. The House stands adjourned until Thursday, May 2nd, 2013 at 10 o'clock a.m.